Good morning. The District Court of Appeal of the State of Florida in and for the Second District is now in session. Those having business before this court, draw near, give attention, and you will be heard. May God save the United States of America, the state of Florida, and this honorable court.
Good morning. Welcome to the Second District Court of Appeals remote oral argument. I'll be calling the cases in the order that they are listed on the docket. When each case is called, there will be a brief pause as you are transitioned into our virtual courtroom. After each case is completed, the participants are asked to leave the meeting and may continue to view online if you wish. As a reminder, each side is given 20 minutes for argument. If you are the appellant, please let me know if you would like to reserve time for rebuttal. We give a maximum of 5 minutes. Please unmute your microphone when you are recognized to present your argument. Please also know we have read your filings, and Zoom can be awkward, so let's try not to talk over one another if someone's asking a question for clarification or something else. So thank you very much. We are ready to proceed. The first case is, and I apologize if I mispronounce the names, it appears to be Gazion versus Gazion. Is counsel ready?
Yes, yes, I am, Your Honor.
Morning, sir. Welcome. Would you like to reserve any time for rebuttal?
Yes, Your Honor, if I may, 3 minutes for rebuttal.
All right, sir. Go ahead, sir.
Good morning, and may it please the court. My name is Jason Scott Coupel. I represent the appellant Paul Gazion. Your Honor, in this appeal, it is the position of Mr. Gazion, who I will also refer to as husband. It's the position of the husband that the court improperly interpreted an otherwise clear and unambiguous prenuptial agreement to essentially negate certain terms of that agreement and to provide the wife with benefits that were not intended had the agreement been interpreted properly. Your Honor, I understand that the court has read the briefs and the submissions. A brief background: the parties entered into this prenuptial agreement before they were married. The wife was pregnant, and the husband had asked for this prenuptial agreement. It was signed and executed by the parties. They both had counsel to review it, and ultimately they continued from there. When the wife filed her petition for dissolution of marriage, she asserted a number of defenses, among them that there was duress, overreaching, and there were other defects that prevented the court from being able to enforce it. By the time that those defenses came to hearing, they had been reduced to 3. Number 1 was duress. Number 2 was overreaching. And third, the prenuptial agreement was violative of public policy. Now, there is one unusual feature of how the trial court handled this matter, and I believe that my colleague, Mr. Maros, will agree with me. This particular trial judge often, instead of creating an integrated final judgment containing all of the issues raised in litigation, will often do what it calls partial final judgments, or it will individually interpret certain documents, and eventually those come together in the end as the court's final pronouncement. In this case, there was a hearing held on the prenuptial agreement, and the court found that there was no duress. The wife had asserted that her pregnancy and the desire to legitimate her child was duress that led her to sign this agreement, which she would not have otherwise done. The court found, according to the case law, that pregnancy is in and of itself is not a form of duress that would invalidate a prenuptial agreement, and that was not the case. The second was overreaching. The court also found that there was no overreaching, no actions by the husband that would in any way make the make it unenforceable. Finally, the prenuptial agreement was found not to be in violation of public policy. The wife's desire to legitimate her child, as she put it, was not sufficient to was not a sufficient impingement on her rights such that the agreement would not be enforced. At that point, Your Honor, the litigation moved into a new stage, and the new stage was that the wife asked the court to interpret the agreement. Now, as it stood right now, the court had found that the agreement was fully enforceable, and that being the case, the court's next task was to interpret the agreement according to its plain meaning, and to determine which assets were and were not subject to the prenuptial agreement. In this case, and this is where we believe that the court erred in its determination. The prenuptial agreement had certain provisions regarding the treatment of income during marriage. There were three of them. One was a provision that said that all the separate property and any additions of funds to the separate property, regardless of the source, would be considered non-marital.
Well, that doesn't include, excuse me, sir, that doesn't include the word income. I realize section 1 is what you're relying on, but I detect that you're not challenging the court's conducting an evidentiary hearing to determine the intent of the parties, are you?
Well, Your Honor, I think that from the beginning, during the proceedings, that trial counsel did in fact suggest that there was no ambiguity here, and therefore that the court's decision to interpret and to take further evidence on the subject was improper.
Well, there really wasn't an objection. So it seems to me it was allowed by consent, because the husband said everything belongs to me coming into this marriage, no matter where I put my income. And the wife testified that throughout the negotiations, she specifically inserted the provision that all parties' income is marital. And that's in section 6. And then there's only one exclusion, which says her 2004 income is exempted. There's nothing in section 1 that deals with income or even says income. So we're dealing with the general versus the specific. And also, your client even agreed that the last clause, except otherwise provided herein, was not agreed by either one of them. And it was added by a non-party. So how is that clear and unambiguous?
Your Honor, I believe that the issue here is not so much that as much as where income could be used within the structure where it would be considered non-marital property. And again, I think that quite clearly that it says, I would suggest that to the court that the comment regarding that someone else added it. I mean, quite frankly, I believe that there was a dispute as to that. I believe, if I'm not mistaken.
No, I looked at the transcript. Both of them testified and they were sequestered. The wife said, I don't know who put it in there, and I didn't agree to it. And the husband said, I don't know either. And your client also said that it's less than clear. This agreement is less than clear. It's not exactly the way I wanted it.
All right.
So then the court took testimony. So I'm trying to get you to address the wife's clear intent in including the language that all parties' income, regardless of the source, is marital.
I think that the issue here in addressing the party's intent is that the court is first required to adopt the plain meaning of the language. Again, that is the best evidence of intent, is the plain meaning of the language.
If they wanted plain meaning, wouldn't they have just excluded that language altogether? Wouldn't that have been the easy way to say that all marital income goes with the party? or wherever the husband wanted it to be. They could have said that very clearly in the agreement if that's what they intended, but it's not what the language says.
Your Honor, I would agree that certainly the parties were free to craft the language as they felt that they saw fit, and certainly I would believe that another practitioner might have treated this differently. However,
But you're saying it's clear and unambiguous.
It is, Your Honor, and that's our position. Is it's clear and unambiguous because of the fact that as it stood, the language was clear and capable of determination. The case law is fairly clear that, like any other contract, if the language is clear and ambiguous, then the court cannot resort to parole evidence or any other intrinsic evidence regarding intent.
Wasn't it your client's attorney who was taking the lead on this and drafting it?
I understand that is the case. However, I'm sorry, Your Honor.
I was just going to ask. Then shouldn't they have a greater burden then to make sure that it is clear and unambiguous?
Well, I mean, again, I believe that obviously that I think that both parties actively participated in the drafting of this, as the wife testified, and therefore I believe that both were responsible for determining whether something was clear or not. I also point out, as the wife admitted, that she had her own lawyer review this language, and there was no objection raised at the time. Additionally, Your Honor, the wife agreed in the first stage of the proceeding, where the court was dealing with the defenses. The wife specifically agreed that there was no attorney influence that somehow affected the enforceability of the agreement. And at that point, again, I believe, and unfortunately, what we believe happened is, by making the determination that the language was ambiguous, which we respectfully submit it was not, and I think that the court opened a door where, even though it had already dismissed these defenses and overruled them, it opened a door where it could reconsider them in a different context. And we believe that was not the proper way of dealing with it. Ultimately,
wouldn't you agree, is it Mr. Capel, wouldn't you agree that the court has the authority, once it determines that an agreement is validly formed, it can still decide whether there is an ambiguity or not, correct?
Certainly, the court has the authority to do that.
Okay, the court has the discretion to do that.
Well, first of all, Your Honor, I would point out that in terms of the interpretation of the contract, it has the discretion to do that. It is subject to de novo review by this court. But at the same time, it has to start with the basic canons of contractual construction, which are, you have to interpret according to plain meaning first, and you cannot result to parole evidence unless there is a real ambiguity. My concern,
what you had before Judge Hellinger was, the husband said, no matter where I park my income during this marriage, however long this marriage lasts, I will reap the benefit of that. I will have all of that property, any investments that I have increased with my income, and I will take that with me in a divorce. And the wife says, no, I specifically exempted my 2004 salary, and I also specifically asked for and got the language in there about each party's income. And the only specific exception in there about income is about the wife's. There's no specific exception about the husband's income in here at all. I know you go back to Section 1, but Section 1 simply talks about property. And as Judge Stargill said, if you wanted property to include income, it's very easy. Now, I understand. I'm going to give you didn't draft this. I get it. And the judge had some concerns about the prior attorney and things like that. So, but you got to deal with what you have.
of course, Your Honor.
So when you have the husband saying, anything that I put my income into during this marriage, which is normally considered marital, unless otherwise provided, he's saying he gets it all. The wife says, no, I specifically did this so that that didn't happen. that seems to be a huge conflict that needs to be resolved by the court, does it not? Did you freeze? I think your screen is frozen. Oh boy. Mr. Capel, we can see you. Now, I think the screen is still frozen. Mr. Capel, you're on mute.
Can the court hear me now?
Yes, sir. Welcome back. Oh, no. Now we can't.
Thank you. Okay. Your Honor, I will call in. Can you hear me now at all?
I can.
You may be able to just turn off your screen and then we can hear you. Sometimes your internet won't pick up both signals.
Welcome to Zoom. Enter your meeting ID followed by pound. Enter your participant ID followed by pound. Otherwise, just press pound to continue. Join the meeting as an attendee and will be muted throughout the meeting. Join the meeting as an attendee and will be muted throughout the meeting. Join the meeting as
Mr. Capel, we can hear you fine. We can hear all of your Zoom things. If you want to just turn off your video and hit stop video, we can probably hear you okay.
Okay. Your Honor, can you hear me?
Yes, sir.
Okay. Can you hear me now?
Yes.
All right. To continue where we left off, the issue here is, I mean, where there is such a conflict, certainly it might merit reconsideration by the court. However, I would point out that the final draft of the agreement did not say anything with the effect that Mr. Gassion could keep all of his income. In fact, the agreement said that all the income was marital except what was delineated therein. So whatever his thoughts were during testimony, they were not reflected in the final agreement, nor did he seek an interpretation to that effect. Moreover, we would point out that the basis for that statement, again, it was, I mean, the court was left with what is the plain meaning before it. One of the problem that we have identified to the court is that the plain meaning was able to be ascertained. And at that point, the court, by going on to take evidence as to the party's intent, that was where the court erred. Clearly, I think that if court reviews the transcripts, I think that the court's concerns in this case were less about what was provided in the agreement and more about what the net effect would be. And again, as the court is aware, the case law provides that a party is free to make whatever bargain he or she wishes, regardless of whether or not that's favorable to that person, unless there is some sort of duress and overreaching that causes that agreement to happen and renders it unfair. In this case, the court specifically found that there was no overreaching or duress on the part of the husband that would make it unfair. So again, we think that when reading everything in pari materia, we believe that the court should not have taken that step next. And what we believe, Your Honor, is that it opened the door for the wife to suddenly claim that that this was not the intent and not her meaning. I point out also that from the beginning of the case, this was not asserted as a defense, that this was somehow not related to her intent or did not accurately reflect her intent. She made specific defenses that were dealt with and addressed. And only after those were addressed did the court then kind of invite. So we would submit, Your Honor, the court should never have gotten to the point where it did. And we believe that if you read all of the provisions in that in such a way where all of them are enforceable, therefore, I believe that the interpretation that was advocated in the brief and by the husband at trial would be the only clear and plain meaning of it. I think that unfortunately, by determining there was an ambiguity, the court unnecessarily muddied the waters and ultimately allowed what we believe was quite self-serving testimony on behalf of both parties to come in and then, to confuse what was otherwise, I think, a very clear issue that the court had to address. Your Honor, I realize that Your Honors have given me extra time for the technology problem. I do believe that I'm over the time that I had asked for and I would like to reserve the rest for rebuttal if that's possible.
You'll get your full 3 minutes due to the technical error, sir. All right. Thank you.
Okay. Thank you.
Maros. Good morning, Mr. Maros.
Good morning, Your Honors. I'm Peter Maros. May it please the court. I represented the wife, Julie Gassion, from day one right up through today related to this entire proceeding. To say that my response here will be brief is an understatement. A few points that I would like to make that have not been made by the court, and although they've pretty much been made, are that absolutely the parole evidence testimony was allowed by agreement. There were no objections at any time to any of the parole evidence testimony. And to the contrary, even after the parole testimony that took place during the trial, there was a subsequent day of trial, as you know, where they agreed to offer more parole testimony about the exact issues outside of the presence of each other. None of that had to be agreed to. None of that, all of that could have been objected to, but was not. And that unobjected to testimony clearly and unequivocally creates a question of fact. Most of these points have been made by Judge Sleet, but the husband's testimony was about as straightforward as it could be, that not only was it on his lawyer that this drafting was done poorly, but that he wished it had been done over again, that it was very confusing. On and on and on. The wife's testimony was very specific as to exactly why the agreement was renegotiated, and remember, redrawn by the husband's counsel to include that all income is marital, excepting only her 2004 income as specifically identified in the agreement. Probably the most critical point here of all is that this agreement very unusually makes all income marital, whereas generally the purpose of a premarital agreement that is protecting assets and protecting income, virtually all of them make income non-marital. And that not only clearly could have been done, but I'm not aware of any case before this court or any other district where there was ever a all income is marital type provision. So it was so specific and so directly related to this case that the concept of specific versus general is about as critical as could possibly be. And of course, the issues of fact were left to the sound discretion of the judge. And not only does his logic appear to be very sound, but there was certainly competent, substantial evidence to support all of his rulings. I want to at least mention, although I don't think it's important here in light of where this argument has gone, but there is a critical issue here about whether or not the record is appropriate and whether or not there are even transcripts that would allow there to be any proof of harmful error. But that's over and above what appears to be obviously something that the judge ruled correctly on. Also, again, as pointed out by Judge Sleet, the only mention of income are in the two paragraphs that were specifically renegotiated. I want to at least briefly mention that there is a claim that the fee award should be reversed. That didn't get argued yet, but it's just simply incorrect to state that the fees were based strictly on equitable distribution. To the contrary, that the judge goes into great detail. He identifies the income, 91% husband, 9% wife. He gives great detail about Rosen factors and the specifics of how they played into his order. And of course, remember here that if this were based on ED alone, equitable distribution alone, and they're asking that that be reversed, that would dramatically increase the husband's equitable distribution, giving him virtually 100% of all of the assets. There is no basis whatsoever for reversing the fee order. And of course, we're seeking an affirmance on all counts. Thank you very much for your time.
Thank you, Mr. Meros. Mr. Capel?
Can you hear me now, Your Honor?
Yes, sir, clearly.
Okay. First of all, in response, the argument that the testimony was unobjected to, the fact remains in the transcript. The husband's trial counsel did, on several occasions, argue that this was unambiguous and that parole evidence should not be allowed. The fact that the court allowed this and determined that it should is not a indication that the trial counsel consented to anything at all. The fact is the court allowed it. With regards to whether or not these provisions are unusual, I have been practicing family law for a great deal of time. Each agreement is different, and there are agreements out there that deal with the sequestration of income. These are not rote agreements. Each is drafted to the specifics of the situation. Regarding the record, Your Honor, we went back and forth in motion practice on this about the record being insufficient. It turned out that 2 of the hearing transcripts regarding the 2 hearings that we've discussed were not included in the record. The court allowed me to supplement. I went ahead and did that. And therefore, we submit that the record is complete and it is sufficient for the court to be able to review all of the issues we've raised. Regarding the fee issue, the case law is clear that if a underlying judgment that a fee agreement is based on is reversed, that it is usually the appropriate thing for the fee agreement to be reversed as well. I believe that my colleague's indication that somehow if the ED was reversed, that somehow that he would have to pay more in attorney's fees, that is somewhat speculative. And the fact, regardless of whether or not the husband would have to pay more or less or the same, it is not, I think, of moment here if the underlying judgment is not well taken. In terms of whether or not the redrawing of this agreement, we believe that what the court did is that it completely redrew what was a clear, provisions were clear. It invited the testimony that it then used to essentially negate the provisions. We believe that those provisions were in section 1 that said additions regardless of source were broad. It is broad, but at the same time, we believe under Hahimovich, I believe it's broad enough to encompass what the income of the parties, if that income was used to add. The only final comment that I will make is that one of the it seems the main concerns of the court and was argued by the wife was that somehow this agreement allowed Mr. Gassione to control everything and to improperly put income into these non-marital properties to the prejudice of the wife. The fact is there was no evidence that ever happened. And so why the court was concerned about that when there was no indication that he had manipulated the monies to his benefit, we believe the court should.
All right, sir, you're at your 3 minutes. If you could just wrap up, sir.
That's it, Your Honor. Thank you for your time.
Thank you very much. Good to see you both. If you could please leave this meeting, and have a nice day.
Thank you.
Yes, sir. Thank you.
The next case on the docket is Amy Marinick versus Progressive. Good morning.
Good morning, Your Honor.
Good morning, Your Honor.
Mr. Sider, would you like to reserve any rebuttal time?
Yes, sir. 5 minutes, please.
All right, you got it.
Thank you.
You may proceed.
Good morning, Your Honors. May it please the court, Tom Sider for the appellant, Mrs. Marinick. And if I may, I'd like to walk this court through the two issues that we raised on appeal. As you know, the first issue is that the trial court employed the wrong legal standard in ruling on Progressive's motion for new trial. And the second issue is that the trial court erred under any standard in granting a new trial on the basis that the verdict was excessive. I'd like to start, if I may, with that second issue because it is the more factually intense of the two, and also because, to the extent that the trial court grants the relief we're asking for, which is reinstatement of the jury's verdict, it does obviate the court's need to even look at that first issue. The second issue on appeal does involve the trial court's discretion. The abuse of discretion does apply, and it is afforded to the trial court. But that discretion does have limits. A court can't order a new trial on grounds not supported by the record, on an objection that was withdrawn or unpreserved, or that was never raised in the first place. And here the trial court did all of those things in finding that two categories of damages were excessive: non-economic damages and also future medical expenses. And I'll start with the future medical expenses, which Mrs. Marinick proved at trial using the testimony of an expert life care planner named Dr. Gandhi. The first finding that the trial court made that we submit was error is the trial court found that Dr. Gandhi's testimony was unreliable or should not have been allowed because he relied on this online database of private healthcare claims. Now, we disagree on the merits. We think it was entirely proper for him to rely on this sort of information, but it is rather beside the point here in that the trial court seemingly forgot that Progressive had withdrawn its objection to that testimony on this basis. Before, on the first day of trial, Progressive had moved to exclude this testimony, saying that Dr. Gandhi was improperly relying on this supposedly improper information. But when it became clear that the trial court was contemplating granting the motion, and that also the trial court was thinking it was going to continue the trial, Progressive withdrew the objection and said, I don't want to raise it anymore. I want the trial to go forward. That is a calculated risk that Progressive took. It affirmatively withdrew its objection. And as a result, it should not have been able to move post-trial to set aside the jury's verdict on the basis that this testimony was supposedly improper.
Mr. Sider, I didn't see in the record where there was an argument about the admissibility of his testimony based on a website. I know that there is a brief scant motion in limine with one paragraph, but was that ever argued before the court and ruled on?
It was never ruled on, Your Honor. It was discussed right before trial began.
Well, then let me ask you a question, because I haven't seen a case like this before where a court grants a new trial and within the order, it concludes that it would have excluded a witness that it allowed to testify when it had not conducted any type of hearing concerning the admissibility of the witness's testimony. Is there a case out there? I mean, because it seems to me, one could arguably say that's non-record evidence. The court has based its decision on, because to grant a new trial, the court has to weigh the evidence, correct?
Correct, Your Honor. And I don't think there is a case that is squarely on point here. This issue was argued briefly before trial began, and that's when Progressive said that it was improper. There wasn't any sort of Daubert hearing or anything like that. And importantly, the trial court never did make a ruling.
Did either party ask for a Daubert hearing?
Not that I'm aware of, Your Honor, no.
So was the court, sui sponte, brought up a Daubert hearing in the order?
Yes, Your Honor, that's my understanding. Or at least there's nothing in the record to suggest that either party suggested a Daubert hearing. And as you said, the motion to exclude Dr. Gandy's testimony was one sentence long, and it certainly didn't make any arguments about Daubert or request a Daubert hearing or anything of that nature. But even if Progressive had done all of those things, once Progressive withdraws its motion and says that it doesn't want the trial court to rule on it, Progressive has waived that forever. Even fundamental error is waived and cannot be a basis for reversal if it is affirmatively withdrawn by the moving party, which is what happened here. And so, I think that the trial court's reliance on this supposed improper basis for expert testimony, it absolutely cannot be a finding supporting a motion for new trial or an order granting new trial. And that is a reason to reverse the trial court's order all on its own.
Well, but there does appear to be some objective evidence the court does base its decision on: minimal property damage, no emergency medical treatment. She didn't comply with medical recommendations and treatment. There's a 2-year gap in treatment. She birthed a healthy child. There's no claim of lost wages. There's 25 grand in past meds. Life care plan based on 25 grand in past meds is $405,000 in future medical expenses. Past pain and suffering, $245,000. Future pain and suffering, $1.5 million. When the court found that she didn't follow up with treatment, although she did have 2 children, I believe, in the interim. But that's not enough objective evidence?
Well, no, Your Honor, not when the trial court is premising its order, is granting a motion for new trial for reasons not supported by the record. I understand that there are, some bases in the record. We would dispute quite a few of the trial court's findings, but once we can establish that the trial court relied on this improper basis in granting a new trial, the order can't stand, would be our position. There is no sort of harmless error analysis that I'm aware of that you can, or tipsy coachman analysis you can do when a trial court errs as a matter of law in articulating the reasons for reversing or rather doing away with a jury's verdict. And there were other problems with the trial court's findings as to the future medical damages. As you mentioned, Judge Sleet, the trial court seemed to take issue with Mrs. Marinek's treatment history. That was a driving force here for the trial court. And what the court said is that because she didn't receive treatment in the past, it's not likely she's going to receive it in the future. The problem here is that Dr. Gandy knew about her past medical treatment and gave his opinion, nevertheless, that he thought there was going to be future medical expenses, that he thought she was going to need this future medical care. The jury relied on that testimony. And so when the trial court here is saying that the jury returned a verdict against the manifest weight of the evidence, what the trial court is saying is that the jury, by failing to reject unrebutted expert evidence, returned a verdict that was manifestly weighted again, or was manifestly against the weight of the evidence. And that can't be how the manifest weight of the evidence standard is supposed to work. It can't just be that the trial court would have decided the case differently.
Did Dr. Gandy also treat your client?
Yes, Your Honor.
That's kind of out of the norm. Life care planners aren't treaters.
Yes, Your Honor. He's also a physiatrist.
So he actually treated her and then also developed a life care plan.
Yes, Your Honor. He did treat her. He had a few appointments with her and then came up with the healthcare plan. Yes. And so in this case, Progressive doesn't put on any evidence about what future medical care is going to be reasonable, doesn't introduce its own healthcare plan, and really doesn't make much of a case at all, and doesn't even suggest an alternate figure to the jury for what future medical expenses would be reasonable. And so it's not really a surprise here that what the jury ends up doing is accepting the only expert evidence that it has in this case, which came from Dr. Gandhi. And I do want to highlight, Progressive admits this in closing arguments. Progressive says, page 807 of the transcript, so in this case, the only information that you have for question number 2 is going to come from Dr. Gandhi. Now, Progressive asked the jury to ignore that evidence, but that doesn't, just because the jury could possibly decide that they didn't want to accept Dr. Gandhi's testimony, doesn't mean that the evidence was manifestly weighted in favor of Progressive. And if anything, the evidence here was manifestly weighted in favor of Mrs. Maronek, because again, we're the only ones that presented any sort of expert evidence here. And really, at most, what we have here is disputed evidence and not manifestly weighted evidence. And as this court held in the Farmore case, which we cite in the briefs, a trial court can't, under these circumstances, act as an additional juror in determining an essential issue based upon what, at most, was conflicting evidence and not evidence that was manifestly weighted to one side or the other. That's exactly what the trial court did here, which is why we submit that the award of future medical expenses needs to be reinstated and the trial court needs to be reversed. I do also want to discuss the non-economic damages. The trial court, again, with this category of damages, raised sua sponte 2 factual issues that had never been raised by the parties in the case. And it did so because it was trying to articulate ways in which the jury may have been prejudiced or may have looked to evidence outside the case in coming in reaching its verdict. And the first thing that the trial court said was that Mrs. Maronek made references in her testimony to her church or religion, and the court is concerned that these remarks were designed to curry some type of favor with the jurors as they bore no other relation to the pertinent facts and issues in the case.
Were there any objections to that testimony?
No, Your Honor, there were none. Not during the trial and not post-trial either. This was not something that Progressive raised in its motion for new trial. It was not mentioned at the post-trial hearing. It appeared for the first time in the trial court's order granting a new trial. So not only is there no record support for it, and not only is it unpreserved, but it's been raised sua sponte, which takes away Mrs. Maronek's ability to explain to the court why this view is incorrect, why she wasn't trying to curry favor with the jury.
On at least one of those occasions, it related to where she was leaving on the way to the event, correct?
That's correct, Your Honor. So there were 2 mentions of her church, and one was she was asked to just describe her morning leading up to the crash, and she said, I was going from church to the Rays game, and the Rays game got much more mention than the church in that narrative. And then the other time was she was describing her relationship with her husband. She does have a consortium claim in this case, or says that she has a loss of intimacy. And all she said was, I met my husband at church. That's it. And so those 2 passing references to church certainly are not evidence that Mrs. Maronek was trying to curry favor with the jury. They don't show anything that would be, cause the jury to become impassioned or emotional or inflamed. And that is probably why Progressive didn't object, didn't say anything about this. And even now on appeal, doesn't try to defend the trial court's reasoning, doesn't try to say that, oh, this might have been something that impassioned the jury. Throughout, this has been something that only the trial court has raised and only the trial court has seemed concerned with. And the same thing is true for this aside about Mrs. Maronek's former boss, Mr. Deason, who came in and testified. The trial court felt like he had this sort of outsized impact on the jury. Again, nothing in the record to support it, was never raised, and was not argued post-trial, something that the trial court put in its order for the first time when it issued the order. And for both of these, in sua sponte raising these issues, there's a due process problem, and there's also the problem of when a trial court starts to raise and adjudicate issues on behalf of one of the parties, it raises concerns of partiality. And we have that here too, on top of all the other problems having to do with an order that's not based on record evidence and is ruling on unpreserved objections. The other non-economic damage findings that the trial court makes are also unsupported by the record. This is an area where the trial court is supposed to be very deferential. The trial court is supposed to, understand that the jury is inherently dealing with something that can't be quantified. We didn't see that sort of deference here. The trial court made a lot of findings that were either, contradicted by the record, or that missed parts of the record, or that mischaracterized the record. So, for example, one of the things the trial court says in the order is Mrs. Maronek, she wasn't as badly injured as the jury must have thought, because she was able to continue all of her employment duties after the accident. But she was not. There was evidence in this case that she struggled terribly at work after the accident. The trial court said she missed no time from work. That's not true either. That she did miss time immediately after the accident, and she missed time repeatedly because of doctor's appointments. It became a real problem at her job. Trial court said there was no evidence she might require surgery. There was evidence that she might need surgery, although we didn't seek future medical expenses for future surgery, but we did have expert testimony saying it's very possible rather that she'll need surgery in the future. The trial court also said she could do everything now that she did before the accident, except for some recreational activities, some activities with her children, and lifting heavy objects. But the
You're
evidence
at 15 minutes. You can use it any way you like, but I just wanted to alert you at 15.
Thank you. I appreciate that, Your Honor. I'll try to wrap up pretty quickly. I just wanted to point out that the evidence showed more limitations than that. Mrs. Maronek testified that she's in constant daily pain. The trial court's order does not mention that. Mrs. Maronek said that she can't sleep at night. She loses almost 2 hours a night from sleeping in her estimation. The trial court didn't mention that. She has trouble being intimate with her husband. That's also not mentioned in the order. And then, the order says that she has trouble with some heavy objects, some activities. That really does undersell things. She can't carry her own luggage. She can't do basic household chores, and she can't even pick up her 18-month-old son. And she gave very affecting testimony about what a big deal that is to her, not being able to pick up her son, not being able to play with them or bathe them or take care of them in the way that she always thought she would be able to. And I guess the last thing I'll end on before I reserve the rest of my time is that the jury's verdict here was not just for a decade or two. Mrs. Maronek was 33 at the time of the accident. She was 36 at the time of trial. Her life expectancy was an additional 46 years. And so the jury's verdict, the non-economic damages, when you stretch them out over that 46 years, it was not clearly excessive, and it did not show any type of passion or prejudice on the part of the jury. And so I'll reserve the rest of my time if I may.
All right, sir. You have 4.5 minutes.
Thank you.
Good morning, ma'am.
Morning. Thank you, and may it please the court. The trial court is presumed to have drawn on her talents, her knowledge, and her experience to determine if the verdict was against the manifest weight of the evidence. It requires a clear showing of abuse to overturn, and that's based on a reasonableness test. Specifically, the trial court's decision, was the trial court's decision reasonable? And if so, it will not be overturned. The appellant is asking this court to reweigh the evidence submitted to the jury in the trial court's place, and that is not the test. The Supreme Court has stated that an analysis of the evidence supporting the jury verdict isn't relevant to the review of an order granting a new trial. Simply because there's evidence in the record which would support the jury verdict is not enough to show abuse of discretion in granting a new trial. The focus is not on the evidence that supported the jury's verdict, but on whether the trial court's decision as outlined in the order was reasonable. And abuse of discretion must be clear from the record to overturn the order. In making its decision, the trial court must consider the credibility of the witnesses along with the weight of all of the other evidence in reaching the determination of whether the jury has reached an unjust decision under the facts.
Let me ask you about Dr. Gandy,
Sure.
because the motion in limine was never heard. You agree with that?
Yes, Your Honor, I do agree with that.
So the admissibility of his testimony was never adjudicated pre-trial, correct?
Correct.
Okay. This court, this trial court, put in the order that she would have excluded his testimony if given the opportunity. She was never given the opportunity. That is sui sponte injecting non-record evidence into a decision to grant a new trial, is it not?
So Your Honor, Progressive would.
Yes or no?
No, I don't agree with the analysis. And
Okay, so what evidence did she have before her, the legal basis for excluding his testimony?
So it's the premise that I disagree with. I don't believe she excluded his testimony.
No, she said she would have excluded his testimony, meaning she didn't believe a word he said, even though the parties never argued the motion in front of her and she never ruled on it.
Well, just a little bit more background. The motion actually was heard and she did rule on it, but then the morning of trial.
You waived the motion. Mr. Hendricks
Correct.
waived the motion. There was no ruling. It's in the transcript. There was no ruling, no denial, nothing. So the court, sui sponte, brought that up, did she not?
She did raise the issue that had been withdrawn, and as far as the objection goes, correct.
Okay, so the determination of the admissibility of his testimony was not an issue during trial,
Correct.
yet it's in the order for new trial.
She does mention it in the order for new trial. But I don't
How is that
believe,
not an abuse of discretion?
I don't believe that she relied on or I guess rejected his testimony in the order outright. She actually incorporated an analysis of all of his testimony into her analysis of whether there was an excessive verdict.
But she opined that she would have excluded the only expert who gave testimony concerning future medical expenses and future pain and suffering. He was the only one.
For the plaintiff, there was an expert presented by the defense.
That was an IME, CME doc. He didn't talk about anything about future medical expenses. He didn't even talk about $1, correct?
Correct. He opined that her
He said she's not hurt.
complaints had resolved.
So is what you're saying, you would have us believe that that was just kind of dicta in the judge's order? There was no reason, just sharing with us her opinion that this expert would have been included if they'd actually gotten to that decision?
Yes, Your Honor, that actually is my position. In fact,
And there
I
was
think
no weight given to it at all. She just wrote that couple paragraphs about the Dr. got, right?
correct. That's my opinion. And I believe that because when you look at her analysis of why the future medical expenses were not supported by the evidence, she goes through a detailed analysis of Dr. Gandhi's testimony and why she believes that it's not reasonably certain that plaintiff will incur the future medical expenses in the future, which is the required test at the trial level for future medicals. So, and she goes through it in great detail without mention of the objection or that she would have excluded him. She goes through every element that he discussed, that he suggested that the medical treatment that she received, and that is how she arrives at her conclusion that they're not reasonably certain by his testimony in conjunction with the plaintiff's testimony and the evidence with regard to her past treatment. She did not write off his testimony as though he had not been permitted to testify. And the record, it's Progressive's opinion that the record doesn't support that the court granted a new trial based on this withdrawn objection. And that it was, like you say, something along the lines of dicta. To go back to the question of the future medical care, what the court did point out is that Ms. Marinek's basis for not seeking the recommended treatment was because of her pregnancy. But if you look at the timeline, it doesn't really work. The evidence shows significant gaps in treatment, times when Ms. Marinette could have undergone any of the recommended treatment at a time when she was not pregnant, whether it be pain management, physical therapy, or chiropractic adjustments, and she chose not to do so.
When you say when she was not pregnant, are you saying immediately before the pregnancy or during the time she was breastfeeding?
Right, Your Honor. So to be clear, there was an 18-month period post-accident and when she was not pregnant. And the initial pain management recommendations were made approximately 6 weeks after the accident. And she didn't seek any of that treatment. She, after her first pregnancy concluded with the birth of her son, she resumed treatment with the chiropractor in September of 2018. And in October of 2019, about a little over a year later, she had her one appointment with Dr. Gandhi. And approximately October, November 2019, she gets pregnant again. So shortly before trial, she was about 12 weeks pregnant. So you have another 11 or 12 months there where perhaps she was breastfeeding at that time, and I recognize Dr. Gandhi's testimony with regard to her ability to receive injections, and that would be counterindicated. But the evidence with regard to other suggestions by Dr. Gandhi and her other treaters was that she undergo other types of treatment, which she chose not to do. For example, sleep studies. Those are non-invasive treatment to try to resolve some of her issues, which she chose not to do. And in fact, her testimony was that in September of 2016, she stopped treating because she was tired of going to the doctor. She wanted to focus on her new job, and she wanted to get into the right mindset to start trying to get pregnant. So
yeah, but see, the jury heard all of these excuses. This isn't something that was withheld from the jury. They knew she didn't treat, but the same Dr. Gandhi who testified about future medical care said she had a permanent injury. Mr. Hendricks said that she deserves 0. Mr. Hendricks' motion for directed verdict was 3 words: did not prove their case. So tell me, the judge brings up her mention of religion and church, and it was designed to curry favor with the jury. How are we, not being there, to decide how much that affected the judge when that particular issue was never in dispute in that courtroom? Mr. Hendricks never objected about it. And then Mr. Deason, how are we to determine how much effect this had when the judge says, Mr. Deason's, and this is why you call a before and after witness, because you want to tell them how she was before and after. And the court says they thought very highly of the plaintiff after Mr. Deason's testament. Well, that's what's supposed to happen if you do your case right. But why is the court weighing in on this when it was never disputed by the parties? Never.
Thank you, Your Honor. So with regard to the question of religion and the testimony of Mr. Deason, the court didn't reach any conclusions regarding these factual issues.
Curry some type of favor is not a conclusion.
No, Your Honor, I don't believe she adjudicated any of those issues by including those facts in the order. There's no formal judgment or decision in this order regarding the evidence that it should have been excluded or.
Well, Progressive didn't seem to be bothered by the testimony, but the judge was.
Right. And so the trial court is required to outline in its order the considerations for granting the new trial, and the various points were included as support for the trial court's ultimate findings regarding the excessiveness of the verdict. The trial court is supposed to consider all that she witnessed and experienced in the trial and making her determination about whether a new trial is warranted, and she's not limited to only certain aspects.
Then it says that they gave her money because she goes to church, and they gave her money because Mike Deason did a good job. That's basically the conclusion to be drawn from here. How's that not the court's personal opinion versus an objective determination of the evidence?
Well, Your Honor, I think the court included these particular issues in the order as factors that figure into the overall determination of the excessiveness decision.
But they were
like all
factors
the
that
other
weren't
evidence.
objected to. I mean, these are issues that came in. How is this not the judge becoming the seventh juror?
So the court, in Progressive's opinion, isn't the seventh juror here because it's the trial court's job to look at all of the evidence and evaluate the evidence and the testimony and make a determination if the jury reached a reasonable conclusion based on the manifest weight of the evidence. And the court went through in its relatively detailed order the testimony about the impact of the accident on Ms. Marinek's life, the testimony from Dr. Gandhi with regard to her future treatment, the
But as Judge
testimony.
Sleet said, the jury heard all of this. They weighed it out. They made a determination. But the three issues that the trial judge really brings out before spending, I don't know, the last 8 or 9 pages talking about other cases that didn't get this much, so that it was excessive. The three issues that we have before us are the Dr. Gandhi testimony, the religion church testimony, and the Mike Deason, being a star witness. Do you agree those are kind of the three things that the court highlighted?
I wouldn't say that the court highlighted them. In fact, I think that the court spent significantly more time on the various testimony of Ms. Marinek, evaluating it as it relates to Dr. Gandhi's testimony and the testimony from her other treating physicians with regard to the treatment she had undergone. I think that she mentions the question about, I think the question about Mike Deason, or the statement about Mike Deason, was maybe a paragraph, and the religion mention also the same. I think she also goes through quite a bit the work history, the fact that Ms. Marinek had not been, she wasn't making a claim for any past lost wages or future earning capacity. She went through the trial court went through all of the various testimony that allowed her to arrive at the conclusion that the jury.
I understand. But besides, the judge maybe didn't believe her as much as the jury did, or maybe didn't like it. But when we're looking at this and deciding whether she abused her discretion, those three things jump out off the page as reasons that this judge highlighted that weren't really, one of them, they withdrew their objection and their motion. The other two were never objected to. So how is that not an abuse of discretion?
Yes, Your Honor, I understand your point. I think the idea is that a trial court, in determining whether a motion for new trial should be granted, outlines all of the various undertaking as far as what it considered and what it believes is in support of for its decision to ultimately grant a new trial, and an inclusion of detail and facts and testimony and evidence with regard to arriving at that conclusion. And it doesn't follow that everything that the court would draw out as to the basis for why it makes the decision is testimony or evidence that would have been objected to. Rather, the court is incorporating all of those things that the court believes may play a part in why the verdict is excessive.
Why would you say it's not then a due process violation at a minimum if the plaintiff didn't have a chance to even respond on the issue of the religious statements or Mike Deason's testimony?
Well, I think that to say that it's a sua sponte due process violation is probably like akin to arguing that then you would have to object to so much more at trial that maybe isn't something that figures into the moment or the testimony or be particularly important. But in the scheme of things, when the trial court is looking at the totality of what happened at trial and all of the evidence in the testimony together and weighing it for whether it's against the manifest weight of the evidence, these are the issues that figure into the trial court's review.
But the flip side of your argument that they'd have to raise all the objections, which I would suggest that that is the trial counsel's job, is to raise these objections. But the flip side of that is to say that based on the facts of this case, two general references to somebody's religion or places that they go could serve as a basis to overturn a jury verdict, you know, coupled with some other things. I understand it wasn't just that, but to allow that to go as not being an abuse of discretion, wouldn't that invite future juries or future judges to bring up those kind of issues and never give a plaintiff an opportunity to even respond?
Well, I think that it goes to, if we think about the order or look at the order, all of the issues that the court raises in the trial, in the order granting a motion for new trial in this case, in theory, the plaintiff didn't have an opportunity to respond to any of those issues that the court raises, but rather the court picks out those particular details that the court believes may have impacted the verdict that indicate maybe the jury acted with passion in reaching its conclusion.
But as you indicated, most of those were based on the plaintiff's testimony and other things that clearly they had a chance to control because it was her testimony. These other factors, the three factors I mentioned, are things that were either withdrawn or she didn't have a chance to respond to. So you can continue. I don't want to take any more time with it, but that's what I'm struggling with on your case.
Yeah, I recognize that, Your Honor, and I would simply say that I believe that the brief mention of those two issues, Mr. Deason and the religion, in the order, in Progressive's opinion, simply serve as the fact as additional factors in light of all the testimony and evidence that the court lays out that figure into the overall determination of the excessiveness. The other thing that the court looked at in this particular case were recent decisions to arrive at its conclusion that the verdict was excessive, and the trial court reviewed 4 cases that had recently been tried in the same venue with very similar facts and defenses, and considered those cases.
But 2 of which didn't have a permanent injury finding.
Correct, Your Honor.
So you really only have 2 cases that are similar. This was a permanent injury finding.
Correct, Your Honor. A permanent injury with regard to the jury's ultimate conclusion. But if you look at the defenses and the actual injuries that were claimed, they're very similar from the onset of those cases. You
got about 30 seconds. Go
okay.
ahead.
The older cases that are recommended or from different jurisdictions shouldn't bear the same weight as those from the similar jurisdiction tried before the same juries in the same time frame. It's not unreasonable that a seasoned trial judge's conscience was shocked by the jury award in this case when the evidence showed that Ms. Maronek had not received 1 injection, had only received some of the recommended care and sporadically at that, and did not have a surgical recommendation. 96% of the future medical award was for pain management, which in the 4 years since the accident had not been any part of her treatment, despite recommendations starting less than 2 months after the accident. Ms. Maronek testified that the only activity she had not undertaken since the accident, which she engaged in prior, was rollerblading. And despite what appellant is encouraging this court to do, it's the trial court's responsibility to weigh the evidence, consider the credibility of the witnesses, and determine whether the jury has reached an unjust decision under the facts. If the trial court's actions were reasonable, then the order should stand, and the trial court's granting of a new trial here doesn't rise to the level of abuse of discretion. Thank you, Your Honors.
Thank you. Mr. Sider.
Thank you, Your Honor. I'd like to start with the argument that perhaps the trial court, although it did say that Dr. Gandhi's testimony shouldn't have been admitted because he relied on the database, that maybe the trial court didn't base any of its ultimate rulings here on that finding. Our argument is this was not dicta. These were not idle musings that the trial court decided to set out in the order. The trial court discussed the reliance on the database because it factored into the trial judge's decision-making. And if that isn't, self-evident enough by the attention that the court gave it, I think it becomes abundantly clear when you look at the actual legal ruling that the trial court made here. On page 168 of the record, the trial court says, applying the facts enunciated at the outset of this order, the court finds that the jury's award of future medical expenses was not a reasonable representation of the evidence. So the trial court saying, based on the facts that I set out at the beginning of this order, I find that the verdict as to future meds was against the manifest way of the evidence. So it's clear that the trial court did in fact base its ruling on those findings. And the same thing is true for this sua sponte issues having to do with Mr. Deason and the church issue. Again, the trial court didn't write these paragraphs for no reason. The trial court, not only for no reason, but unsolicited. The trial court didn't do that because it wasn't important to the trial court. The trial court clearly was bothered by it and it factored into the decision-making here. Now, Mrs. Warden-Brooks suggested that, it's not fair because some of this stuff maybe wouldn't have warranted an objection, but they still want to raise it. They still want the trial court to be able to consider it post-trial. That is antithetical to the rules of preservation. If something doesn't warrant an objection, then it's not objectionable and it can't be used as a basis for granting a new trial. And then the only other thing I wanted to mention is that, this discussion of past treatment history that Ms. Warden-Brooks discussed today and how there was, some spotty treatment in the past, as you pointed out, Judge Sleet, this was squarely in front of the jury. It was a central issue in the case. And the jury did take this into consideration. It could not have missed it. And so the question becomes on appeal, was the evidence manifestly weighted in favor of Progressive on this? And the answer is no, it was not. That this was a disputed issue of fact. And the only way for the trial court to decide this case in Progressive's favor was for it to step in and act as a seventh juror. And for all these reasons, Your Honor, we would ask that the court reverse and order that the trial court reinstate the jury's verdict. And I'll rest now unless Your Honors have any further questions. Thank you. Judge Sleet, you're muted. I didn't know if you were asking me a question or not.
I'm on mute. That's the problem. We don't have any questions. Thank you. All right. If you could leave the Zoom meeting. Our next case, Hillsborough Insurance Recovery Center versus Progressive American Insurance.
Judge Sleet,
Yes.
Attorney Kohler was having some technical difficulties this morning, so he is calling in.
Okay.
Okay?
Do
Thank
we
you.
have him on the line?
Yes, sir.
Yes,
He's
Your
there
Honor.
and ready.
And Mr. Higgs is here? Well, I'm sorry, it's Mr. Dawson. Okay. All right, Mr. Kohler?
Your Honor, I'd like to reserve 5 minutes for rebuttal.
Okay. You may proceed, sir.
Thank you, Your Honor, and may it please the court. The trial court here, sua sponte, rewrote the appraisal clause when it created a good faith negotiation requirement prior to invoking appraisal and struck the mandatory component of appraisal. Neither of the parties requested this relief. Essentially, what the trial court did is it bailed out Hirc, which is a collection agency who received this claim to assignment from Clear Vision, who actually did the windshield repair, from a bad business model where they did not consider the cost of appraisal. This court has ruled in Progressive Insurance Company versus SHL Enterprises that the costs of appraisal are the costs of doing business. Hirc bought this claim knowing full well that Progressive's policy contained an appraisal provision. That's on page 319 of the appendix. Mr. Shate, who owns Hirc, testified to as much. He also testified that he would incur some costs in litigation when the case went to litigation. So there's two issues here. Number one is the sua sponte rewriting of the appraisal clause to include a good faith negotiation requirement prior to invoking appraisal. And second, there's the striking of the mandatory component of appraisal, which would essentially let one party go to appraisal only if the other party agreed. Right, as the policy is written, both parties, once appraisal is invoked, it becomes mandatory on both parties. Court's order changed that. Now, as to the first issue, the court cannot grant relief that is not specifically requested in the pleadings or raised by the parties in the hearings of the motions. This case only involved an evidentiary hearing on one issue, the prohibitive cost doctrine. That's the only issue that was raised by Hirc, and that's the only issue that was noticed for that hearing, which occurred on June 4th, 2020. Trial court cannot raise issues sua sponte. In this case, the issue of the good faith negotiation requirement was not raised by any of the parties. The court raised it sua sponte, which is not proper under Morocco versus Breivik, 99 SO 3D 416. And while there are some cases that have been given to the court as supplemental authority here, Rettelhammer, and I believe the other one was a certain underwriters association. I don't quite recall the name, but I can distinguish those readily. Number one, the issue wasn't raised in this case. Second, it's not relevant because there was a post-suit invocation of appraisal in form of Progressive's motion to compel appraisal, which is proper under Florida Insurance Guarantee Association versus Castilla. The courts allow a motion post-suit to suffice as an invocation of appraisal, even if it hasn't been done properly pre-suit. In this case, Progressive argues it was done pre-suit, but also argues that it was also done post-suit through that motion. In Rettelhammer, you had instances where the party seeking appraisal had not actually provided their amount of loss position to the other party. So it required a meaningful exchange of information, which did not happen in those cases. Here, we did have a meaningful exchange of information. The invoice came from ClearVision to Progressive. This was before it was assigned to Hirc. And after that point, Progressive made a payment to ClearVision, which eventually assigned its claim to Hirc. So ClearVision knew what the position of Progressive was on the amount of loss for the entire period. And then it assigned its claim to Hirc, which also knew what Progressive's position was on the amount of loss. There was nothing in Rettelhammer about good faith negotiation, just a meaningful exchange of negotiation so that you have enough information to actually do an appraisal, which is both parties' positions on the amount of loss.
Did Hirc attempt to negotiate with Progressive before filing suit?
I do not believe so. I believe what happened is you had the invoice from ClearVision, it went to Progressive, Progressive made the payment, invoked appraisal, didn't hear back for some time. I don't recall exactly how long it was before they filed suit. It was a couple months, I think. And after that point, Hirc filed suit. So there were no meaningful negotiations on that point. The other issue is that insurers, the only post-loss duty here for Progressive would have just been informing Hirc or ClearVision before Hirc of its position on the amount of loss. It's not a situation like you had in Romay, where the insured was invoking appraisal and had a set of post-loss duties that they had to comply with before they could invoke appraisal, so that the insurer had ample information to evaluate and investigate the claim. Now, the second issue is the matter of the striking the mandatory component of appraisal. This is not proper under 627.428 because that doesn't deal with cost of appraisal at all. In fact, recently, several days ago, the 5th DCA ruled that 627.428 doesn't apply to an appraisal provision because there are some rare circumstances where attorney's fees might still be received. For instance, if the insured had to file suit because the insured had to file suit because the insurer did not comply with the appraisal provision, refused to pay the appraisal award. So there, it just simply isn't a situation where you can apply 627.428, which deals with attorney's fees, to appraisal costs. They're two different things. Appraisal is an attempt to resolve the dispute within the contract. It is only when the claims negotiation and adjusting process breaks down, the parties are no longer working to resolve the claim, that you end up in a situation where there might be attorney's fees under 627.428, but that's only when the suit serves a legitimate purpose under Esposito and Farinato. If it does not serve a legitimate purpose, then there are no attorney's fees under appraisal in those instances, even when there's a confession of judgment. So this just doesn't, 627.428 just does not apply to attorney's fees. It applies to attorney's fees, it doesn't apply to appraisal costs, which are the costs of doing business. Secondly, it's a prevailing party requirement, and there is no prevailing party in appraisal. All you do is you're determining the amount of loss. You don't determine the amount due under the policy, and a progressive appraisal provision doesn't say that it determines the amount due under the policy. It's just determining the amount of loss, which plaintiff cannot unilaterally set under the precedent in First Call 24/7, and Progressive's payment of its determination of the amount of loss is not breach of the contract. So there were several tipsy coachman arguments raised by Hirc. The first one was limits of liability. Those are not applicable to appraisal. The only thing determined in appraisal is the amount of loss. The appraisers are not using the limits of liability provision ever. They just determine the amount of loss. If it were to be applied afterwards, then that would be a different matter, but Progressive just pays the appraisal award. It doesn't go any further than that. There was an allegation about data that's also not raised, not applicable, because there's no breach. The payment is not breached under Chen, and all we're doing here is deciding the amount of loss. We're not deciding the limits of liability provision in appraisal. The limits of liability provision is what they want the data for. There was also a tipsy coachman argument on mediation. Neither party requested mediation in this case. Whether there was precedent, whether that was a condition precedent to appraisal, was also not raised. There were no rulings on this. There's actually a mediation clause in the contract which specifically states that either party can demand mediation unilaterally, and it makes the parties split the cost of mediation, so it wouldn't really put Hirc in any better situation than appraisal. But in any event, this is not a condition precedent to the invitation of appraisal by Progressive. It did not have to offer to Hirc mediation. Hirc could have just demanded it itself, and then it would have to file the proper form with the Department of Financial Services according to the policy. That didn't happen here. The coverage issue raises the tipsy coachman arguments. Same thing, limits of liability, not raised, not applicable. And in terms of coverage, whenever you see somebody stating that there's an extent of coverage, that's just talking about the amount of loss. We're not talking about what kind of risks under the policy are covered here. We're just talking about the amount of loss. And the 11th Circuit had a great opinion on the distinction in Southern Owner Insurance Company versus Eglin Rose Association 872 F3D 1161. There was also a tipsy coachman argument on equity. However, you don't get equity if you don't request it. The court could not have done this in equity because Hirc did not request it. You can't get in equity what you can't get in law because equity follows the law. A good case on that is Simon versus Walters, cited in the reply brief. And furthermore, you can't get equity to remedy a self-created harm. Here we have a self-created harm. Nobody forced Hirc to buy this claim. It did so knowing full well that there was an appraisal provision in it. And Hirc's owner admitted as much, again, on page 319 of the appendix. So what we have here is appraisal costs are the cost of doing business. They're not attorney's fees. In fact, attorneys can't actually participate as an appraiser because they're not a disinterested party under Branco. So the situation is we have Hirc attempting to have the courts bail them out of a bad business model that did not consider one of the essential costs of doing business, which is cost of appraisal. Furthermore, there was a citation to a case called Saris in the answer brief. That was an issue of statutory interpretation and preservation. You don't get to preservation if it was never raised by the parties to begin with. And I understand that the position of Hirc is that they did raise it because it's exactly the same or substantially similar to the prohibitive cost doctrine. But the only issue they raised here is the prohibitive cost doctrine. The court, in its order, denied that the prohibitive cost doctrine applied here. In fact, it said, although the reasoning is somewhat similar, and the court has used the phrase economically prohibitive, the prohibitive cost doctrine does not apply because the filing fee alone costs more than the appraisal process costs. As for the cost of the appraisal process, the testimony from Mr. Raskin was that it costs $125 per claim because he's able to do them in bulk and they don't take as long as your normal automotive claim, do a windshield claim. And all these cases, in this particular set of cases, we have another set scheduled for argument in a few minutes. But here, these are all windshield repairs. So the amount in controversy is about $25 for each one. So it is a small amount, but that doesn't justify going in and striking the mandatory component of appraisal under 627-428 when that statute deals with attorney's fees. There's a different statute that deals with costs, but that's not what we're dealing with here.
Is there anything within the policy that excludes windshield claims from being subject to appraisal?
Nothing, Your Honor. The only mention really in the policy, I think, is they're not subject to the deductible, which was the issue under 627-7288 in Progressive American Insurance Company versus SHL Enterprises, which was a case this court decided a couple years ago. So there really aren't a lot of mentions of windshields in the policy. It's an appraisal provision that applies to claims for physical damage, whether they're collision or comprehensive. Here we're talking about comprehensive claims. And there's no exception in the policy for windshields, nothing. And if the court doesn't have any further questions, I will reserve the remainder of my time for rebuttal.
All right, sir. You'll have 5 minutes. Good morning, Mr. Dawson.
Good morning, Your Honor.
You may proceed, sir.
Thank you. May it please the court, Joseph Dawson for the appellee in this case. I've written down your questions, Judge Sleet, so I'm going to try to get to them for you. Let me start by saying, and I'm going to address a point that you made at the end. Does the policy have any exclusion for windshield claims as it relates to appraisal? And the answer is no, specifically it does not. And that's the exact reason why equity cries out for a public policy application to the analysis of these claims, given the small amount that is in dispute, which, as we know, is
that public policy determination be made by the legislature, though?
I would suggest, Your Honor, that given the finite and precise nature of these claims, juxtaposed against the background that windshield repairs are a public policy consideration to make sure that they get repaired, thus no deductible. But it's up to the courts to fashion an equitable remedy in the event that the application of a policy provision becomes inherently unfair. Most of our appraisal cases that we read from the appellate decisions deal with homeowners' claims that are
across the state. There is an outcry of people saying, I have this $25 or $50 problem with my windshield for a policy that I entered that had this appraisal provision in there, that people could talk to their legislators and say, please exclude that. This is treating me unfairly. But how are we as an appellate court to know when we should step in and allow a trial judge on his own to determine what that equitable public policy should be?
Well, first, Judge Gerber in the fourth DCA in the Saris case that was mentioned by opposing counsel says that even the appellate court, if it's not raised below for the first time, can fashion an equitable remedy. Here, the plaintiff did seek an equitable remedy. The judge just thought it wasn't the right equitable remedy. And as a consequence, he fashioned one which was not dissimilar. It was just not on the same legal name and basis.
Well, let me ask you a question.
Yes, sir.
Judge Moody denied you on the prohibitive cost doctrine, and now the fourth DCA has weighed in on it and doesn't apply to appraisals. So we have precedent.
Yes, sir.
But my question is, I understand equity, but equity does not allow us to rewrite private contracts. Your client is in a risky business. He decides to buy windshield claims in bulk. These policies provide for appraisal for claims. They don't have any exclusion for windshield claims, and everybody knows they're de minimis. And it seems that below, someone convinced Judge Moody the fact that they're de minimis, you're not going to make money. But there's no law that says a court can rewrite a contract to benefit somebody that made a bad bargain.
I think that the analysis has to include the fact that, number one, Progressive demands appraisal even before they deliver.
You can demand it too. It's bilateral.
But the problem is that we don't get that chance to. Clear Vision just submits its charges. It doesn't know that there's going to be a dispute. What has to happen is that the insurance company has to do their adjusting analysis, determine what's the appropriate amount to reimburse at that amount. They should provide an explanation of benefits that enables the insured to analyze whether or not the payment is consistent with the policy's provisions. And then, and only then, it can be determined whether or not a dispute exists.
Well, you're making arguments that everyone else failed to do. Clear Vision didn't respond to this whatsoever. Your client buys these up, doesn't even communicate with the insurance company at all, and files suit, and then claims fees.
That's because in their letter demanding appraisal, Progressive utilizes a standard that's of payment inconsistent with the policy's provisions. If you look closely at the appraisal letter, it's at page 106 and 107 of the record. It says Progressive has determined that the amount that was billed was not reasonable. However, the policy says that we will not pay an amount that exceeds the prevailing competitive labor rates in the area where the property was repaired as reasonably determined by us.
Right. And if Clear Vision disagrees, they can get their own arbitrator, and that issue can be resolved without judicial intervention, without litigation. And it's a condition precedent, and your complaint alleges that you fulfilled the condition precedents. I don't see that.
The problem is that the standard by which payment is to be made is not the one that the Progressive appraiser and the umpires utilize. Because
that's not what you argued below, sir. You argued prohibitive cost. You said this is a de minimis claim. I'm not going to make any money. It cost me way too much to go to appraisal to try to get $90.
And that's why I believe
you didn't argue coverage.
Well, no, because we didn't get a chance to. Because by demanding appraisal before you deliver the payment and arguing that once appraisal is demanded, it vitiates any ability to contest payment, it disenables the plaintiff to even argue that they're applying the wrong standard. And that's why I believe Judge Moody recognized through a public policy analysis the unfairness of them to determine that this is merely a pricing issue. As he pointed out.
What case supports Judge Moody excising the mandatory appraisal language from the policy, a private policy, for equitable reasons? Give me one case.
Well,
Don't give me an arbitration case. Give me appraisal.
I would, Your Honor, point out that he relied upon the Blankfeld case. And in the Saris case, we argued. But the fact of the matter is that equity is something that is, and public policy is a very fundamental power that the courts have to deal with inherent inequities and unfairness. Not every insurance policy fits every single appropriate dynamic. And in this particular instance, given the small amount of the controversy, it was inherent upon him to recognize that making a party pay $250 to litigate $50 is unfair. And if we say, well, you entered into a bad deal, what happens then is the insurance companies like Progressive can continue in an unfettered way to trample on the rights of their insured to get these chips repaired. And that's the problem. And so we leave it to the courts to, when they take these contracts that are adhesion contracts with an insurance company, we enable them to utilize their equitable powers to determine what's fair and unfair. And
Well,
given
if
these
we agree with you, Mr. Dawson, here's our problem. We're going to have to recede from web roofing, which clearly says that an assignee must comply with the contractual terms of an insurance policy, including the appraisal provision. We would have to recede from that.
Judge,
I can't hear you.
I'm sorry, I was just waiting for you to finish your question.
You're good now.
Thank you, sir. What if by demanding the appraisal in the way that Progressive did, it supersedes all of the other elements of the contract, and therefore the insured has no ability to raise the fact that the insurance company breached the contract because they have to go to appraisal? That's I think the problem that exists when you demand appraisal at the same time that you make the payment. Our allegation in the statement of claim is that they breached the contract because they didn't define the payment provision and they were applying it in an inappropriate way. What is our opportunity to have a court consider that breach of contract element if we have to go to appraisal where they don't consider those elements? This is not simply a dispute as to the amount of the payment. That's a very simple broad brush analysis that is often done. Rather, this is a case concerning whether or not Progressive properly implemented its payment provision as contained in the policy.
Yeah, but 4 months before you filed suit, 4 months before you filed suit, there's a certified letter to Clear Vision and the insured saying, we don't agree. We recognize a dispute exists as to the amount necessary to repair. You had this knowledge is imputed to you. Your client, Hirc, did nothing. They filed suit.
I would point out.
And now you're raising an issue you didn't raise before Judge Moody. You said it costs too much to go to appraisal. Now you're arguing up here some sort of coverage issue.
Well, we have to bear in mind that the issue of raising the prohibitive cost doctrine was only one element of our objection to going to appraisal. And as a consequence, it's only that precise issue that's before you today. However, I think that given that Judge Moody employed a public policy argument, we'd need to take a look at the demand for appraisal letter to see that it clearly articulates a different standard of determining the amount to reimburse than is contained in the policy. Because Progressive is arguing that by demanding appraisal, it vitiates any other complaint that the plaintiff may have regarding the policy language being appropriately implemented. It exactly serves the purpose that they have, which is to weaponize the demand for appraisal in order to emasculate any ability of the insured to attack whether or not Progressive was acting within the appropriate manner given the policy language.
Well, your argument would apply to any claim, whether it's for $1 billion or $90 windshield.
The argument of the cost disparity.
You're just making
would
this
not.
argument because it's such a small amount.
Well, and that's why I would suggest that we're asking for a very precise and unusual remedy because the amount in controversy is so small. As Judge Moody pointed,
your colleagues were successful in getting the legislature to deal with the deductible issue, which I think was a fair result. It seems to me that Judge Stargell has a point. This is a highly regulated industry. And we're not in the business of interfering with private contracts to rewrite them. The legislature has yet to enact a law saying that carriers must foot the entire bill for appraisal. They can't share the cost with the insurer.
The point we are making is, given that this is an adhesion contract and arguably doesn't really apply to these small claim cases, given the huge disparity between the amount that it costs to go to appraisal versus the amount that's in controversy. And it's our position that very wisely and cleverly, Progressive is weaponizing that provision in order to avoid our even being able to contest the amount that they are paying on the claim.
Well, that's like arguing that a PIP policy wouldn't apply to a $15 claim. The PIP policy appraisal provision wouldn't apply to a $15 claim.
You know, I've never seen a PIP case go to appraisal, Your Honor, and I've done
had appraisal.
Well, if
We'd
it
have
had
to carve out that exception too.
I think that this type of a public policy argument was one that the trial court could utilize on a case by case or issue by issue basis to determine its applicability. After all, at the end of the day, equity is the power that the Chancery Courts of England gave to the judges to correct wrongs, to remedy injustices. And given these particular facts, and I'm not saying that whatever remedy is fashioned for these types of claims would apply to any other or every other case. I'm certainly not saying that. That's the whole point of
But in
equity.
essence, you are. If you're saying that judge by judge throughout the state, they're going to get to determine what public policy is, any de minimis issue that becomes something throughout that, you know, somebody sits back and contrives and says, hey, what about these issues? They're only $40, $50 each, but we'll go out and have a business model where we're going to make sure everybody knows they can do this. That's for the legislature to determine whether you exclude it. It's not for trial judges to decide that these are de minimis and therefore we rewrite their contracts. When you talk the public policy side of it, I'm not, understanding where we draw these lines.
I think that, Your Honor, we have to entrust to the trial judges and believe
Okay,
that.
well, I think that the first line of your explanation explains to me where you're coming from, because I would entrust the voters to elect their elected officials to make the laws of the state. Even though they also elect the trial judges, they elect them to be judges and not to make the laws and apply the laws.
To respond briefly to that, Your Honor, I understand and get your point. However, we're dealing with insurance contracts, which are long, and we're dealing with a lot of different types of claims and cases. And at some point, we have to entrust in our judiciary the wisdom to make the call when equity should apply and a public policy argument should apply to protect the insured from the insurance company, such that Judge Moody pointed out what would stop the insurance company from routinely only paying at 50% of the value if they knew that if any insured contested that it would be economically unfeasible. And that's what he's trying to protect
I'll answer
against.
that for you. What would
Yes.
stop that are the public's elected officials who would have an outcry and say, this isn't just, this isn't fair. But there's contracts, and all the time people choose not to repair. If you have a fender bender, doesn't meet your deductible or what other items in your policy, you don't get there, then you don't recover. But if the insurance companies are across the board acting improperly, then that issue can be addressed by the legislature, not letting on a judge by judge cases, have them rewrite those policies or write their own law.
Well, I think the legislature's plate is pretty full, but I understand your argument.
Hey, could you address the distinction that was discussed in the briefs about the disparity between the amount in question and the cost of appraisal versus the disparity between the actual expense of litigation versus the cost of litigation?
Yes, sir.
Even if we were, if this court and I'm sure you've gotten the impression about what members of this court may or may not do with regard to whether they would affirm the implementation of such equitable doctrines. But if it was to be affirmed, would it be applicable at all?
I got the court's drift to answer the latter part of your question. As to the first part, first of all, I disagree with opposing counsel regarding the filing fee cost. It's a small claims case. It's usually less than, I think, $125. I don't know what it is in this particular county, but that's not the significant difference in my argument. The problem is that the appraisal letter employs a different standard than the policy utilizes for the purpose of determining the amount to reimburse. And as such, the appraisal is going to automatically utilize a different standard. And the only way for the plaintiff to enable the court to make sure that the prevailing competitive labor rate standard, as is contained as the policy, is properly applied to the claim, is to file the lawsuit alleging that, and it may not have been as artfully drafted as Judge Sleet would like, and I don't necessarily disagree with that. But the point is that the lawsuit was intending to clarify that the provision in the policy that applies to determining the amount of reimbursement was a prevailing competitive labor rate as charged in the area of the repair. And then the second part of that sentence, as reasonably determined by Progressive, because the policy creates a reasonableness standard in applying the data to the loss on the part of Progressive, there needs to be some ability to scrutinize whether or not Progressive acted reasonably in determining the amount to reimburse. And I would ask that you affirm the trial court with respect to his order. It seemed as if Judge Moody attempted to utilize his powers of equity in a manner which is consistent with the nature of the facts of the case.
Thank you, Mr. Dawson. All right, Mr. Kohler, still there, sir?
Yes, Your Honor.
All right, you got 5 minutes.
Thank you, Your Honor. The first thing I'd like to address is the appraisal letter and the claim that it's a different standard in the appraisal letter than the limits of liability. There's a difference between the limits of liability and the amount of loss. The limits of liability is the amount due on the policy. The amount of loss is not. The amount of loss is just what the value of the claim is, which under the policy, Progressive is allowed to estimate that using even third-party systems. But it is allowed to estimate the amount of loss, and it is allowed to make a payment of the undisputed portion of the amount of loss contemporaneously with invoking appraisal. Now, there's been some argumentation here that you wouldn't know what the prevailing competitive labor rate is without data from Progressive on how they were calculating that, but that's not what's going on here. The amount of loss is not the same thing as limits of liability. These are two completely different clauses. It's important not to mix them up because the limits of liability has nothing to do with appraisal. You get your amount of loss from appraisal, and then if the insurer wanted to, it could limit that using the limits of liability clause. Progressive doesn't do that. Progressive just pays the appraisal award. So there's a distinction here we have to abide by. Secondly, opposing counsel has mentioned weaponized appraisal. That's a premature bad faith claim, not raised below and not proper in the contract phase of the case. Third, equity. Again, there's rules to equity. They didn't request relief in equity when you have to request it to get it. You can't get an equity which you can't get in law, and that's specific to attorney's fees. You can't get an equity attorney's fees which you couldn't get in law and attorney's fees. Third, it's a self-created harm because they knew about this appraisal provision and bought the claim anyway. Therefore, additionally, there's an ongoing course of conduct between these parties as far as meaningful exchange of information. There's always an invoice sent by ClearVision to Progressive. Progressive makes its payment of the amount that it determines as the amount of loss, and then ClearVision just sells the claim off. It never accepts anything less than the amount of loss. They sell the claim to Hirc, and Hirc sues. So this is not a situation where you're going to have meaningful negotiation of any kind. The parties just need, under Rettlehammer, the parties just need to know what their positions on the amount of loss are, and that's all you need to go to appraisal under Bettelhammer and the other cases like that, which again is not applicable because they didn't raise the issue of invocation of appraisal in this case. They only raised prohibitive cost doctrine, and Progressive, in any event, invoked it post-suit by filing the motion to compel appraisal.
I have a question.
So,
You stated that the clients knew about this provision and bought the policy anyway, but your opposing counsel is saying these are adhesion contracts. They have to do this. What's your argument there?
Well, they don't have to buy the policy. They don't have to buy the claim from ClearVision. They could just decline to buy the ones that have an appraisal provision. There's nothing saying that they have to buy this and then pursue a suit on it. And again, they admitted that they knew about the appraisal provision on page 319 of the appendix. Secondly, this is not a situation where only one party can invoke appraisal. Both can. So it's the adhesion contract argument just doesn't hold weight. Hirc just could have declined to buy any claims where there's an appraisal clause. Here they
would you describe the auto insurance business in Florida a competitive market?
The auto insurance business, sure, between different insurers trying to get customers to sign up for their trying to get drivers to sign up. Sure.
I mean, you can't watch a ball game without seeing 4 different companies commercials, right?
And Progressive certainly does its fair amount of advertising.
So in addition to the legislature addressing this issue, if it became a huge issue, the market itself could address this issue. The customers.
Right. If customers don't want this, they just don't buy policies that have it.
Okay. Thank you.
So I see that my time is up. I just respectfully request the court reverse this case and remand back to the trial court. Thank you, Your Honor.
Judge Sleet, you're muted. Judge Sleet, you're muted again.
You know, I would be a poor man if I had to pay $1 for every time somebody told me that. Sorry about that. Thank you both. Well argued. We're going to take a 10-minute comfort break. We will resume at 11:30. Let's make it 11:35. All right. We'll stand in recess. All right. Good morning. We're back from recess. The fourth case is we once again have Mr. Kohler with Progressive American, and we have a new attorney, Mr. Higgs, for Shazam Auto Glass. Mr. Kohler, are you still via phone, sir?
Yes, Your Honor.
Okay, we hear you loud and clear. Are you ready?
Yes, Your Honor. I'd like.
Would you
to
like 5
reserve
minutes?
Yes, Your Honor.
Okay.
Okay, so this case is similar to the last one we just argued, though there are some differences. First off, this being a window replacement rather than a repair, and there's not a double AOB in this case. It is a single assignment of benefits from the insured to the glass shop. So those are the two factual differences, but the trial court decided to apply the same order that it applied in the other set of cases, which sua sponte rewrote the appraisal clause, creating a good faith negotiation requirement that was not raised by anybody, and also striking the mandatory component of appraisal, which also was not raised, at least as the trial court phrased it, by any of the parties in this case. We maintain our position that this is essentially a bailout for the glass shop, knowing full well that there's an appraisal clause in deciding to do business with these insureds anyway. It's essentially trying to get a bailout of a bad business model where it doesn't consider the cost of doing business, which is appraisal costs. And again, Progressive American Insurance Company versus SHL Enterprises 264 SO3 1013 was the case where this court decided that appraisal costs are costs of doing business. So what the court did here is it didn't actually allow any hearing on the issue of whether that order from the other set of three cases would apply here. Instead, it just sua sponte applied it. There had been a hearing in this case at one point on the issue of whether there would be an evidentiary hearing on the prohibitive cost doctrine and any other issues that Progressive wanted to raise. And that evidentiary hearing was granted by the trial court. The issue is it never happened. The trial court didn't follow through with that. Progressive filed a motion for a stay pending some other appeals that have since been resolved and canceled the hearing after it was scheduled. And at that point, a few days later, the trial court issued this order, which sua sponte applied the order from the other four cases, Wolf, Gill, and Ernessa Johnson, to this set of five cases, finding that prohibitive cost doctrine does not apply in the appraisal context. So it reapplied that finding, but also striking the mandatory component of appraisal to resolve the conflict between appraisal and public policy in 627-428. Now, I've argued this point in the last several cases as far as the issue of striking of the mandatory component and the good faith and the addition of a good faith negotiation requirement, which essentially rewrote the contract to insert that. The additional issue in this set of cases is due process. Progressive contends that the trial court needed to give it a hearing on whether this other set of orders would apply to this set of cases. The trial court can't just go and take the set of facts from the Gill, Wolf, and Ernessa Johnson cases and then import them into these. That's not proper, and it's not how stare decisis, or to the extent he's considering the stare decisis and applying his own order, works. Under Rubrecht versus Cone Distribution Incorporated 95 SO3 950, you can't do that. You have to abide by the facts in the case that's before you. But there were no facts in this case because we never had the evidentiary hearing. Plaintiff Shazam filed an affidavit of Sean Martineau. However, that affidavit was never admitted to evidence at any point, and you can't just file an affidavit and have it become record evidence. You have to actually have it admitted under Dominguez versus Bayview Loan Servicing 221 SO3D 699. So we have a case here where there just isn't any record evidence, unlike the other three where they actually had an evidentiary hearing and had a couple witnesses testify. Here, there's no witnesses. You got an affidavit, but it was never admitted into evidence. So we just don't have anything to go on here. There's no competent substantial evidence. I know plaintiff is saying it's overwhelming, but there is none. So Progressive's due process rights were violated here because it is entitled to a hearing on whether that other order applies, since it just was sua sponte, applied out of nowhere, and also the ability to cross-examine Sean Martineau, who submitted the affidavit, which is not part of evidence because it was never admitted. So that is the main difference between this case and the other case. Otherwise, the same arguments would apply to issues 2 and 3 concerning the rewriting of the contract to insert a good faith negotiation requirement prior to invoking appraisal and the mandatory component of appraisal. Plaintiff has raised a number of tipsy coachman arguments. The problem with that is, in order to raise a tipsy coachman argument, it has to be based on evidence in the record. We have no evidence here at all. And it also has to be based on a factual finding made by the trial court under Blanos versus Workman. That didn't happen here either, but I'll address them. The first one was access to the court's jury trial and due process. Not raised, not ruled on by the trial court. No evidence, no factual findings. And to the extent that there's any argument that in some of these claims, the named driver was the party that signed the assignment of benefits rather than the named insured, there's a joint individual interest clause in the policy which binds anybody claiming benefits under the policy to the named insured's decisions. So the decision of the named insured to accept the policy binds anybody else making a claim on it. And I can quote it: if there is more than one named insured on this policy, any named insured may cancel or change this policy. The action of one named insured will be binding on all persons provided coverage under this policy. So there's that. Additionally, there's the recent 5th DCA case, Mendoza Insurance Company, which rejected this argument, finding that appraisal is valid. It doesn't violate access to court's jury trial or due process. The second tipsy coachman argument regards the retained rights clause at the end of the appraisal provision, which states that neither we nor you waive any rights under this policy by agreeing to appraisal. This issue was not raised below. There's no evidence on it. There's no factual findings on it. And furthermore, it doesn't work the way that plaintiff is claiming it works. The insurers are permitted to include retained rights provisions in their policies. That doesn't make it ambiguous. And even if it did, the claim made by plaintiff that somehow that the last resort canon of construction to construe it against the drafter in favor of the insured would apply doesn't work here, because there are other canons that would apply even if this was ambiguous, namely that the retained rights provision is a general clause and the rest of the appraisal provision is a specific clause, and the specific would prevail over the general.
Mr. Kohler, I have a question about the order itself. I understand that arguments, I think by Mr. Higgs, would have occurred sometime after the other cases that we just heard. They were in February, this was in April or something like that, but you're right. The court adopted the order, which for brevity, Hirc AAO1 Gill. Do we even have an order denying the motion to compel appraisal in favor of Hirc AAO Amanda Stevens?
Well, let's see. Amanda Stevens isn't Hirc. So Amanda Stevens would be Shazam Auto Glass.
Okay.
Hirc was the other set of cases.
Well, but the only order we have in the Shazam case, is there a Shazam order?
Yes, it is on page 297 of the appendix.
Gotcha.
For the Amanda Stevens case.
All right, sorry, go ahead.
It just says, no problem, Your Honor, glad to clarify. It just says that he was applying the order from the other 3 cases, Gill, Ernesta Stevens, and Wolf, finding that the predictive cost doctrine does not apply in the appraisal context, and striking the mandatory component of the appraisal provision. It's a little unclear whether he also included the good faith negotiation requirement or not. I'm assuming he did because he adopted the whole order here, and then he denied the motion to compel appraisal and stay discovery.
I'm clear. I'm sorry to take up your time. Go ahead.
No problem, Your Honor. So I was talking about the retained rights provision, Cincinnati Insurance Company versus Canon. Ranch Partners 162, SO3D 140 is the applicable case for that. Again, you don't have to reach it because there's no evidence in the record, and you can't do a tipsy coachman argument unless there's evidence in the record. And also, it's factual findings supporting it. The third tipsy coachman argument was appraisal procedures. This is essentially arguing that appraisal needs to have all the procedures of arbitration. It's pretty clear under Allstate Insurance Company versus Suarez that appraisal is not arbitration, does not require the same procedures. And again, that issue was not raised, was not part of the trial court's order.
Well, the policy says that arbitration is binding. If you go through arbitration, Mr. Higgs' clients go through arbitration, how can they file suit?
They can't, Your Honor, and this is appraisal. I don't recall whether we have an arbitration provision as well.
I mean, if they go through appraisal, how can they file suit?
They're not supposed to, Your Honor. They're supposed to go to appraisal before they can.
No, but if they go through
had
appraisal and the policy says appraisal is binding.
Right.
How are
It
they
is
able to
binding
file
on the
a
issue.
lawsuit?
Right. It's binding on the issue of amount of loss. I guess if there was some other issue remaining after that on coverage, they could potentially file suit, or they could file suit if the insurer refused to pay the appraisal award. But other than that, they would not be able to. Plus, there's a clause in the policy, legal action against us. We may not be sued unless there is full compliance with all the terms of the policy, which there has not been because they did not go through appraisal. So that's all the new things that are different in this case from the prior case that we just argued a few minutes ago. Otherwise, my argument is largely the same, just that these issues were not raised. The invocation, good faith negotiation requirement prior to invocation was not raised, is not applicable. There's all the issues I talked about last time about Rettelhammer and how it doesn't apply because you're just looking at, just need the position of both parties on the amount of loss procedure appraisal. You don't need anything else other than that. And the problem with Rettelhammer and the cases relating to it was that one of the parties had not given that position, and it was the party trying to invoke appraisal. So that was the problem there. That is not a problem here because you have both parties' positions. You have the invoice giving Shazam's position, and you have the position of Progressive in the form of the payment that Progressive made to Shazam contemporaneously with invoking appraisal. And making that payment does not constitute breach under the case First People's Trust versus Chen 333 SO3D 208 from the 4th DCA. So unless there are any other questions regarding the differences between this case and the other one around the issues that we've already discussed quite a bit in the prior oral argument, I don't want to just keep beating those issues to death here. So unless the court has any questions, I'll reserve the remainder of my time for rebuttal.
I don't think that we do. You'll have 5 minutes, sir. Mr. Higgs, good morning. Welcome.
Good morning. May it please the court. Good morning, Your Honor. I'm Earl Higgs, and I represent Shazam Auto Glass, who I'll refer to as Shazam in this case. We believe that the trial court properly denied the motion to compel appraisal, and the court should therefore affirm. One of the issues that came up several issues came up in the prior oral argument where counsel for Progressive was obviously making the argument there, and I wanted to make sure I addressed some of those. One of the questions or issues that came up in that argument, because they relate specifically to this case, is regarding condition precedent. And in order for there to be an appraisal, the court has to first determine whether it was a valid written appraisal, there were appraisable issues, and whether there was any waiver of that issue. So you don't even, appraisal is not even appropriate unless a court first makes the determination whether those issues have been met. And the court in this case determined that, pursuant to the public policy issues that are infused throughout the automobile legislation and the automobile policies in the state of Florida, that the court fashioned an equitable remedy that it thought would take into account the public policy procedures that are infused throughout the automobile policies in this case. And so when the court, when I believe it was Judge Stargell, and I'm sure Judge Sleet as well, was concerned about, well, how can we as courts weigh in on public policy? Shouldn't that be the legislature? Well, the public policy is addressed in 627-428. As this court determined in Merrick, this court determined that the purpose behind 627-428 was to discourage insurance companies from contesting valid claims or not appropriately paying claims pursuant to the policy. The public policy behind 627-428 is to make the insurers whole. And so what the court, we believe, correctly determined was that by allowing the insurance company to steer the insurers to the appraisal process, they circumvent, they evade the whole public policy purposes behind 627-428, which is to make the insured whole. The insurer can't be made whole when they're steered to the appraisal proportion of the policy. Not to mention, one of the questions, I believe, was Judge Atkins had a question about the disparity between the cost of appraisal versus litigation. And as the court is aware, in this case, in the state of Florida, litigation is free to a prevailing party, especially under 627-428. What the appraisal provision does in this case is it prevents that free litigation to a prevailing party. It actually costs my client, in this case, Shazam, money to engage in the appraisal process, money that my client won't be able to recoup back. My client never has the opportunity to challenge, which is one of the issues that Judge Sleet just brought up. My client never has the ability to challenge whether Progressive is paid the correct amount under the insurance policy. The policy discusses the fact that it needs to be paid based upon the prevailing competitive rate in the prevailing market. How do we challenge that? There's no way for us to challenge that.
Isn't this a business model issue? The part of your business model relies on not having to pay those appraisal fees, but your company made that choice knowing that these appraisal provisions are in there. That's my first question. Then I have a follow-up question for that.
Sure. I don't think it's necessarily simply just a question of a business model. Again, the public policy is specifically set by the legislature in 627-428. The public policy of 627-428 is to make the insured whole. And so the fact that my client engages in business that allows them to bring suit doesn't mean that they give up the right to be made whole in this case. And so I don't believe it's just a matter of a business model.
Well, and the legislature just addressed a lot of these issues, and I'm not real familiar with what the new ones are because it's not come before me. But in that legislation or any legislation, they could have addressed that issue if they saw it as a huge public policy issue, correct? They could have said, well, appraisal, we can't have people requiring assignees or anyone else being responsible for that. That should be the insurance company's responsibility.
Well, I don't think the legislature has addressed this specific issue with regard to appraisals. Most of the case law we deal with arbitration agreements, and we know that there's.
Well, but that makes my point. They had sessions regarding it. It's gone before them. I'm sure your clients could have brought it up to them. The legislature could have acted on the public policy aspect, but they didn't. But even before then, when this was in place, there's no de minimis exception. There's no other requirements regarding this, is there?
Well, no. Again, let me make sure you understand what my point. The business model is not the business model, rather, but let me make sure you understand my point. The public policy is specifically set in 627-428. The public policy behind 627-428 is to make sure that insurance companies make the insured whole. Okay,
and that's on it. So, that's on attorney's fees, though, correct?
Well, that is on attorney's fees, but it's also, again, it's also to make sure that the insurers are made whole with regard to their costs as well. And so, the insured, again, in the state of Florida, the prevailing party has a free of cost litigation once they prevail, and so. Because the state of Florida has determined it's important that the insureds are able to be made whole as a result of the litigation that the insurance company improperly pays a claim or improperly contests a claim, then the the public policy behind 627-428 kicks in.
Yeah, I understand your position on that. Let me ask you my second question. As to 627-428, the recent case that came down, Mendota Insurance, I guess is how you pronounce it. The 5th DCA disagreed with the position you're taking today. So what would you have us do? You want us to come out with a different decision and certify a question up? That's what you're asking us to do now?
Sure, I think, again, well, first of all, that decision is not final yet. It's not, and I was actually attorney of record on that case, so that decision is not final. And the time for filing motions for hearings and things of that nature are still, there's still opportunity to do that. But yes, obviously, we think that the Fifth respectfully did not get the decision correct. And we would ask this court to take a fresh look based upon the facts in this case. Also, Mendota is distinguished because there are various factors with regard to how that case, came out that are distinguishable from this case. For example, there was no affidavit and things of that nature. So we'd be asking the court to take a second look, a fresh look at it in this case. And so the court is not bound by it and could take a fresh look at it and make its own determination with regard to public policy and arguments with regard to 627-428.
Okay, thank you.
So again, in this case, the trial court essentially fashioned a public policy remedy that it thought would take into account the issues that were raised in this case. So there was no valid, we believe there's no valid agreement because it violated the public policy behind 627-428. This court in Flyer Printing and in Hope has previously determined that a arbitration, again, that was an arbitration, but this court is, and we will present that it's similar and analogous with the arbitration agreement, such that when an agreement such as that, an arbitration agreement restricts the right to recovery of statutory fees, this court has determined that that arbitration agreement is enforceable. Again, that's what we submit has happened in this case. The appraisal provision and that progressive policy restricts the right to statutory right to recover attorney's fees, and this court has already made that determination again in Hope and Flyer Printing. With regard to the access to court, counsel mentioned that the argument wasn't raised below, but that argument was specifically raised in Shazam's response in opposition to the motion to compel. Shazam raised the fact that there was no record evidence that there was any knowing or voluntary waiver of the access to courts or right to jury trial. And this court has even pointed out the fact that the ambiguity that is in the appraisal provision. So for example, the appraisal provision binds the parties to the amount determined by the loss, but at the same time, in the case that neither party waives their rights under the provision of the appraisal provision. There's absolutely no record evidence that my client or even insurer for that matter waived any right to access to jury trial, right to access to court in this case. One of the issues that counsel brought up in his argument was that the retained rights in those cases that says the appraisal provision can allow retained rights, but all of the cases that counsel cites to are cases that deal with retained rights one way. That is, the insurance company retains the rights one way. That's significantly different from what we have in our appraisal policy provision in this case. In this case, both parties retain the rights to waive. Both parties retain their rights. They're not waiving any rights. And so because both parties retain those rights, the only right that it makes sense, but it's logical, that it allows the insured, in this case, my client who stepped in the shoes of the insured, to challenge the amount paid under the appraisal provision, challenge to make sure that the progressor paid the appropriate amount under the policy. And so we believe because there was no valid agreement, the court was correct in fashioning this mandatory provision, striking this mandatory provision of the policy. One of the other significant issues also is the fact that one of the factors the court must look at before it can even determine whether there's an appraisal, whether you can go to appraisal, is whether there was a appraisable issue that existed. We contend there was no appraisable issue that existed because there was never a disagreement. In order to have a disagreement, you have to have a meaningful exchange of information between the parties. Unilateral payments, such as the one that Progressive made in this case, never signify a disagreement in the policy. As we cited to in our brief, we mentioned Couch, and Couch talks about the fact that, and I quote, a disagreement is triggered between parties in an appraisal context. Well, Couch was talking about arbitration, but we know that we're similar with regard to that aspect. Difference of agreements, a disagreement is triggered when there's an existence of a real difference of fact arising out of an honest effort to agree between the insured and the insurer. Is necessary to render operative a provision in a policy for arbitration of differences. Furthermore, there must be an actual and honest effort to reach an agreement between the parties, as it is only then that the clause for arbitration becomes operative, the remedies being successive. So our position is there was never any real honest effort to try and reach an agreement in this case. Progressive just simply unilaterally made a payment and requested appraisal without any real effort to make a determination whether there's a disagreement. You don't have an appraisable issue here. And we submit that because there was no appraisable issue, in addition to the fact that we didn't have a valid written agreement, then the court's order was appropriate.
Well, wouldn't that be reading into the appraisal provision? Wouldn't that run into the same problems addressed in the argument you just listened to that my colleagues have raised, which is that if we were to agree with you that there must be some showing of a good faith effort to reach agreement, that this court would be rewriting statute instead of allowing the legislature to do that and implementing, or I guess, excuse me, not the legislature, sorry, the parties to the agreement to write a different statute, or allow the legislature to impose regulation on such appraisal provisions.
Absolutely not. And then we addressed this in our brief, Your Honor. Again, the law we submit, and I just read the law, Couch, Rome, all those line of cases, the red hammer case that counsel talks about, all those cases are all on fours, and that is the law of the state of Florida. There needs to be a disagreement. There hasn't been a meaningful exchange of information in order for the parties to even determine whether there's a disagreement or not. In this particular case, the insurance company, Progressive, just sent a check, and they provided a receipt, but didn't explain exactly what they were paying for. My client couldn't even determine, and he mentions in that he couldn't even determine whether are they paying for some things or not paying for other things. And so,
what information needs to be exchanged other than the information that we think the amount should be a amount lower than requested, and this is the amount we think it should be, in order to achieve what triggers the right to demand appraisal, which is that the parties cannot agree?
Well, again, I believe Couch addresses this, Rome cases addresses it. They also, there's got to be a meaningful exchange of information in order for the parties to make a determination whether there's a disagreement or not. So you got to tell me, if you're paying for something, you got to provide me with an explanation of then. So you can tell me what you're paying for. So I can say, oh, you know what? That's not a disagreement, but this portion, this aspect of it is. And so we believe the law specifically requires it. So it doesn't require this court to rewrite the policy because the law already requires it. And in fact, Appellee's own policy provision requires it as well, because in the policy, the language reads, if we cannot agree with you on amount of loss, then we or you may demand an appraisal of amount of loss. We believe that policy, in conjunction with the law, with Couch, Rome cases, and all the other line of cases, specifically requires the court, the parties to engage in a meaningful exchange of information. And so the argument that the court, in this case, sua sponte, raise these issues about negotiation, we believe that's absolutely incorrect. The policy and the law requires them to do so. And all the trial judge did in this case was apply Gill exactly the way the law and the policy requires it to do so.
Yeah, but can't we presume that your client who is in the business of repairing windshields knows what they're doing and they have the sophistication to be able to repair and or replace, and they know how much it costs, and that their bill that is submitted to Progressive is correct? I'd take that as a yes. So, and next,
Well, no,
Progressive then gets the bill. They disagree with the bill and issue a check at a lower amount and say there's a disagreement. What else needs to be done?
But a disagreement as to what? I mean, I don't.
You
again,
charge too much is basically what they're saying, I guess.
But we can't make that assumption. We can't guess. They have to specifically tell us what the disagreement is. And if we submit, the law requires them to specifically tell us what that disagreement is. So what those issues are, so we can determine whether there is a disagreement or not. We can't simply just assume or guess. They've got to provide us with an information. And when they don't, we believe this policy provision violates the law and their own provision, because they don't provide the information necessary for us to determine whether there is a disagreement.
But
So for the trial court to even determine
your
whether
client could
we should
have
go to-
requested mediation.
My client doesn't have to request a mediation. There's
You
nothing in
can.
the policy that requires it requesting mediation.
But how is it reasonable to say that you don't even know what they based it on, but yet you file suit? If you file suit, you're basically filing sworn pleadings that they're wrong. But yet you're telling me you don't know what they're basing it on, but then you're filing suit saying they're absolutely wrong. Doesn't make sense.
No, that's not what I'm saying. We filed suit because they didn't pay the amount that they were supposed to pay under the.
Okay, so you're
the
certain
policy.
about the amount. So that there
What's that?
appears to be a bona fide agreement about the amount of loss.
No, that's the point of the lawsuit. We disagree as to what they paid, and the only way for us to challenge whether they paid pursuant to their policy. Their policy says they have to pay based upon the prevailing competitive rate. We believe they haven't paid that amount, but we can't just say it. We have to prove it. The way to prove it.
So it sounds like you disagree about the amount of loss according to your lawsuit, but you believe there's no disagreement about the amount of loss for the purposes of appraisal.
I didn't hear your question.
You asked earlier what were the, we're confused about what they don't agree about, and it's the appraisal says amount of loss. That's what it's about. And you, from what you just said, it sounds like you, according to your lawsuit, disagree on the amount of loss.
Yeah, well,
you're saying there is no disagreement on the amount of loss.
Well, let me make sure our position is clear. We see this, we don't see this, we don't concede, and we don't see this as an amount of loss case. We see this as a policy interpretation case, whether Progressive paid the appropriate amount of the prevailing competitive market rate. That's what we see this case. So this is a policy.
What's the amount of loss? What does that mean?
It was under the policy you're asking me, or what my opinion of what the amount of loss is.
What does amount of loss mean?
Well, it can mean several. The amount of loss can.
What does it mean? Well, aren't we here based on the appraisal provision?
What's that?
Aren't we here based on the appraisal provision?
Yeah, the amount of loss is based upon.
So what does it mean in the context of the appraisal provision?
The price. Or the amount that the parties of the.
So explain to me the distinction between that and a disagreement over what the policy requires regarding the let me go scroll up here and see what it says.
While you're doing that, you're at 20 minutes, Mr. Higgs, but I'll give you 2 more minutes.
Okay.
Answer the question.
I don't want to misquote the prevailing competitive labor rates.
Correct. That's what the policy says. The policy says that Progressive has to pay based upon the competitive prevailing rate.
Doesn't a disagreement about that constitute a disagreement about the amount of loss?
Well, but before you can get to that, the court has to first determine whether you even had a valid contract. That's what Romney talks about. That's what the case law talks about. And we submit, and the trial court found that it wasn't a valid contract because because it violated public policy behind 627-428. So before you even get to that, the court's got to first address the threshold requirements before you even get to appraisal. So for the reasons that we've stated in our brief and we've argued here today, we respectfully request the court to affirm the decision below.
All right, thank you very much. Mr. Kohler?
Yes, Your Honor. All right, so, yes, Your Honor. Okay, on the issue of what the amount of loss is, again, we have to distinguish between the amount of loss and the limits of liability. Limits of liability are just the maximum amount that Progressive would have to pay, but that's only if you invoke them and you actually decide to limit the amount of loss based on limits of liability. They're two separate things. They're not one and the same. The amount of loss is something that Progressive can estimate. And under the settlement of claims provision under 237 of the appendix in its policy, we may use estimating appraisal or injury evaluation systems to assist us in adjusting claims under the policy and to assist us in determining the amount of damages, expenses, or loss payable under this policy. And it says, there's a little bit of a gap here, but it says amount, then you have of damages, expenses, or, and then you have loss. So you have amount of loss right there in the policy. Secondly, Progressive's policy in the appraisal clause is different from the policy in Romay, Rettelhammer, and the other case that was filed, certain underwriters. It says if we cannot agree with you on the amount of loss. In Romay, Rettelhammer, it said if you and we cannot agree on the amount of loss. So you have different policy language here. It's much more unilateral in its wording than the policies in Romay and Rettelhammer. But in any event, the issue with Rettelhammer Romay was that there was the party invoking appraisal was not giving their position on the amount of loss. And the amount of loss is simply what the insurer and the insured believe this claim is worth. It isn't about the limits of liability. That would come later if the insurer wanted to invoke that to limit and reduce the amount of loss to whatever the limits would be. Progressive doesn't do that. Progressive just pays the amount of loss determined in appraisal. So I think that's a critical distinction we have to keep in mind here. Secondly, I think they did raise the issue of access to court's jury trial and due process in their response to the motion to dismiss and compel appraisal. However, they did not raise the issue of invocation. The closest they come, I think, well, they didn't really come very close. It would have been, they argued that Progressive had waived appraisal by making the payment unilaterally, contemporaneously with appraisal. That's on page 215 of the record, where they argued in this case the defendant did not deny coverage. Instead, the defendant made a unilateral decision to pay a lower amount without first participating in the appraisal process, which it purports to invoke after the fact. So I don't think the issue has been raised in their, neither at the hearing nor in their response to Progressive's motion to dismiss, stay, and compel appraisal. So the issue here is just simply what is the amount of loss. It's not what the limits of liability say. It's not what the prevailing competitive price is. The appraisers can do whatever they want, really, as far as determining what the amount of loss is. They're not bound by the limits of liability clause at all. So all this issue about we don't know what they paid under as though it's going to some sort of line item is irrelevant. It's the only issue here is the amount of loss as a total. It's not whether there's line items under that or not. It's just what the full amount of the value of the claim is, the amount to, in this case, it's the amount necessary to repair the vehicle by replacing the windshield. In the other case, it would have been the amount necessary to repair the vehicle by repairing the windshield. That's all we're talking about here. So in conclusion, this is just a situation where Shazam is attempting to get a bailout from the courts on a bad business model where they did not consider the cost of appraisal, which this court has ruled is the cost of doing business.
By making the distinction you made, I'm anticipating Mr. Higgs arguing that that might have been his point all along, which is that by merely paying an amount lower than what was requested, that doesn't communicate the requisite information to put the insured on notice to understand that there's a dispute about the amount of loss, as opposed to, for instance, a dispute amount of a liability limitation that caused the insurance company to.
I think they're on notice. I think they're on notice in the letter where they argue that when Progressive says reasonable and necessary, it's not the same as the limits of liability costs. So I think they're on notice about that. And you're invoking appraisal, so obviously you mean the amount of loss, or you wouldn't have it quoted there. I mean, we quote the entire appraisal provision and say we're invoking it. So I don't think there's any confusion at all on that point. I notice my time is up, and Progressive would ask that the court reverse the order on appeal. Thank you.
Thank you very much, both of you. Well argued. If you could leave the Zoom hearing and have a nice day, please.
Thank you. You too.
You as well, Your Honor.
All right, our last case, Blake and Deborah Ewing versus John Cassidy and Richard Saba.
Yes, good afternoon, Your Honors.
Good afternoon, sir. Mr. Kalaya, you're representing the appellant.
Yes, Your Honor, may it please the court. My name is Timothy A. Kalaya from the law firm of Stumphauser, Fosslid, Sloman, Ross, and Kalaya. I represent the appellants in this case, and for ease of reference, I'll refer to them collectively as the Ewings. I'd like to reserve 2 minutes for rebuttal.
You got it, sir. Go ahead, sir.
Your Honors, the Ewings purchased a home from the appellee, John Cassidy, and prior to closing, the Ewings received a home inspection report that identified certain defects. After closing, the Ewings learned of other defects that they did not discover prior to closing and which were not identified in that inspection report. Worse yet, the evidence in this case shows that Cassidy, the seller, as well as his real estate broker and agent, knew about but intentionally concealed many of these defects. Now, the core issue in this appeal is whether the Ewings are barred from pursuing claims relating to the undisclosed defects merely because they learned of certain other defects in the home prior to closing. The answer is no. The Ewings are not barred from pursuing these claims.
Could you let's start at square one. Could you explain to us what you believe the standard should be for the scenario we have here? There were certain things disclosed. Maybe lay it out. I mean, for each of your claims, what the standard should be. Some of your claims are fraud-based, some of your claims are not. What the Johnson versus excuse me, you tell me. You know what I'm talking about.
Yes, Your Honor. So Judge Atkinson, I think the law
that doesn't apply to every case. That doesn't apply in commercial. Sometimes there's exceptions to it that apply only in commercial settings. On the other side is going to have the opportunity to do the same thing. What's the standard?
Absolutely, Judge Atkinson. So 37 years ago, the Florida Supreme Court ruled in Johnson versus Davis that a seller of a home who has knowledge of latent defects.
I've read. We read the phrase. Just what's the standard?
The standard of review or the standard of what?
It's which of your claims does Johnson versus Davis apply? And in which of the claims does it not apply? And what is this? What is the takeaway from Johnson versus Davis? And has it been amended by further courts?
Sure, absolutely. So the claims at issue that were resolved on summary judgment are count 2 for misrepresentation and non-disclosure. That is a Johnson versus Davis claim. Count 3 is a fraudulent misrepresentation claim. We think that involves a similar standard. Now, obviously, there's materiality and reliance, but they are based on a failure to disclose facts relating to defects in a home. So similar standards will apply. Count 4 is negligent misrepresentation. And then count 5 is a Johnson versus Davis claim versus the broker and agent. And count 6 is a negligent misrepresentation claim. So the standard really does overlap. And, as the court has acknowledged, the Supreme Court in Johnson versus Davis says that a seller has a duty to disclose latent defects that materially affect the value of the home. And both parties have cited to various cases that have interpreted and expanded this case law over the years. The courts have made clear that the level of diligence required by a buyer is different in cases involving misrepresentations or fraud. So this is a case, Your Honor, where we have allegations of misrepresentations and fraud. And last year, the 4th DCA, interpreting Johnson versus Davis and the other cases the parties cite in their briefs, concluded the following. When a defect, even when a defect can probably be discovered through the exercise of diligent attention, the requisite level of diligent attention is of less importance in claims involving misrepresentations, especially those involving fraud. That's the Lorber case from the 4th DCA. And in that case, the 4th District Court of Appeal explained that even when there are clearly observable defects that may have put a buyer on notice of an issue, the seller's misrepresentations about that issue are sufficient to establish a claim. So with that context, I'd like to just walk the court through a few examples of the types of defects.
While you're on there talking about that, I'd like to, let's focus on 5 and 6 first, the broker case. The agent knew that day when they brought it up that there's probably not 300 feet here. That was a mistake. They had the opportunity to get a survey, did they not?
So that is a disputed issue of fact. What
Well, no. I'm asking you.
Oh,
if this was important to them, they could have bought a survey, right? There was no obligation on the seller to provide the survey, even though you all asked and he said, I think I might have one. There's no obligation for them to provide the survey, correct?
I don't know of a standard under Florida law where a seller needs to provide a survey.
I'm looking at the contract. There was not a provision in the contract requiring the seller to provide that proof of the 300 feet, correct?
But that's correct, Your Honor. But I think where this turns to is we need to look back at the Florida Supreme Court case of Bessett versus Bassett. And that case is very similar to this one here. In that case, does
that case apply outside of a commercial context?
Your Honor, it has been interpreted in other cases. It talks generally about the standard. Now, the standard is more stringent in a residential context. So in a residential context, obviously, the caveat emptor.
That commercial versus residential distinction is cutting your way, you're saying, and I'll just go on.
Exactly. So in the Bessett case, the sellers misrepresented the size of the property and said it was approximately 5.5 acres. Now, it was actually 1.5 acres. Like the appellees here, the sellers argue that the property could have been determined to be less than what it was available to be or what was represented by the sellers. And that's the same here. If the sellers if the buyers in the Bessett case had performed a survey or looked at various property records, then absolutely they put it.
Can I clear something up? I mean, talking about the level of diligence, concealment. They didn't even have to be diligent. Weren't they provided something right before closing that apprised them of the fact that it was a lot less than 300 feet?
Well, that's another interesting issue, Judge Atkinson, and that was an issue that certainly we raised on reconsideration. The Ewings
on reconsideration. Who cares? I mean, I'm sorry to be so pointed about it. Who cares about what the supposedly fraudulent issue that was on reconsideration? Tell me why the trial court, anybody, the finder of fact should care.
So on this issue, on whether they learned the morning of the closing, there's a disputed issue of fact.
When I say who cares, I mean your late filed supposedly fraudulent eureka moment about this survey.
Right. So the Ewings had been repeatedly asking for the survey, and it was only the morning of the closing that the broker and agent finally delivered that to Mr. Ewing.
But to go back to my point, if this was so important to them that they needed 300 feet so they could subdivide or market it for all of that, they could have gotten a survey under the contract at any point up to closing. And even when one's provided to them and they look at it, regardless of whether it was fraudulent, they made a decision seeing it. I mean, I know your claim is, oh, they've changed something on it. It was the dates that you were talking about later. But at that point, they could have not closed if it appeared that they had not got confirmation that there's 300 versus 100 feet of frontage.
Judge Stargell, that was the morning of closing. The sellers refused to extend the closing date. So under the facts, there's a dispute about whether the Ewings relied upon this, could have reasonably relied upon it, what their knowledge was. Those are disputed issues of fact that should be resolved at a trial where the court weighs evidence.
When did they learn about closing?
They knew the closing date, obviously, when they signed the contract.
So if, a week, 2 weeks before, they don't have a survey from the seller, they could have called and got a survey, correct?
They could have, and ultimately they obtained a survey on the morning of the closing, which turns out to be a fraud. Now, this goes back to the standard investment.
Well, we don't know that you're making a claim after the fact that it was a fraud. This is not something a court or anyone has found. You're making that as an assertion.
That was
my point. Is you want us to rule against the seller because they did a favor and said, yeah, I think I've got a survey. I'll provide it to you.
Well,
and they provided it to you, and your client didn't stop the sale and didn't get their own survey. So why should we, as to the broker, find that that's a misrepresentation or a fraud when they admitted the listing had something incorrect and you should go check it out?
Well, and it does go back to that. So the Bassett case says a person guilty of fraud should not be permitted to use the law as his shield, nor should the law encourage negligence, which is your concern, Judge Atkinson and Judge Stargell. However, and the court continues, when the choice is between the two, fraud and negligence is less objectionable than fraud. Though one should not be inattentive to one's business affairs, the law should not permit an inattentive person to suffer loss at the hand of a misrepresentative.
Okay, so fraud requires something more than misrepresentation, and the supposedly gotcha eureka discovery after the fact was that the date was wrong. So doesn't fraud require reliance? In other words, you have to say, we on the eve of trial, on the eve of closing, what was provided to the purchaser was a document that on its face reduced the waterfront property length by 2/3, and you're saying your client relied on that to go to closing? That's backwards. It's backwards, isn't it?
Right, Your Honor. It's not on the content of the survey. And there's been nobody has assessed that survey. Nobody's looked at the survey to see if there are.
Just walk me through the fraud. You have to say there was a misrepresentation and it induced us to go to closing because we relied on it. Hey, now that you've told us that that of something that reduces the value of the property we're about to buy, I'm more inclined to go to closing. So does that make sense?
Your Honor, the broker and agent admit that they knew prior to closing that the water frontage was less than 300 feet, and they admit that their listing included false information. It said,
and they told the broker or the I don't know if he's a broker or just an agent for the buyers,
absolutely,
right up front. So you were on notice.
Well, a realtor is on notice, but not the Ewings.
Oh, okay. So I see. You think that information that goes to the agent that's represented, there's a problem with, I guess, my understanding of the agency theory. So walk me through that.
So it's a question of fact. So the argument is that they told the Ewings agent, the realtor, about this discrepancy, and therefore this knowledge should be imputed to the Ewings through an agency theory. But the Ewings,
so the agent, they discussed that there's 300 versus 100, so we need to get their survey and we need to keep demanding the survey, but he never told them that they admitted that there's less than 300.
Exactly. So it's a question.
So why aren't you suing your agent?
Well, frankly, that was a claim that was in a motion for leave to amend, which is also on appeal. We wanted to sue the agent because we believe that he didn't do his duty to the extent he was told by the sellers.
Before we get to the leave to amend, could you answer my question? Because I mean, you can please be frank and tell me I'm missing something. But if you're invoking all these principles that have to do with fraud with regard to the 300 feet, and fraud requires not only a misrepresentation and not only intentional misrepresentation, but reliance upon it to induce them to go to closing. But what was supposedly fraudulent was something that actually would have actually decreased their motivation to go to closing. Could you please square that circle for me?
So on this particular issue, on the water frontage, the fraudulent statement was the property listing. There's a forgery potentially related to.
I know, but I thought the smoking gun was that the survey that was provided was itself fraudulent because of some sort of ancillary discrepancy.
So that is a fact. That's a consideration related to this claim. But the main thrust of it is that the property listing said that the property was 300 feet of water frontage. That was what was always represented to the buyers. That's what they believed to be the case. And there's a question of fact about whether they were told by the agent, whether they were told by their own realtor that it was something other than that. And the Ewings have sworn the evidence in front of the trial court was a disputed issue of fact.
But before we move on to the other issues, which you probably should, let's back up for a second and get back out of the fraud milieu and talk about the Johnson versus Davis and say how does their walking the property and all this evidence, that undisputed evidence that they were skeptical and they found it dubious that this was 300 feet, not satisfy the Johnson versus Davis in favor of the seller?
Well, so that is one issue. Obviously, we're talking about the water frontage. There were a number of defects that were raised by.
All right, let's go to these other defects. Okay, fine, good.
Sure. So, for example, let's talk about the electrical. As both parties pointed out in their briefs, the Ewings learned from the inspection report of two minor electrical issues. First, there was an outdoor receptacle that didn't have a weatherproof cover. That's a simple fix. You can buy a new cover from Home Depot for $5. And the second issue was a double tapped breaker. Basically, what that is a breaker in a panel that has two wires connected to one breaker. Again, a relatively simple fix. Those are defects. Those were disclosed absolutely. And therefore, the Ewings can't pursue claims based on those two issues. But those were the only two minor electrical issues they learned about in the inspection report.
On that, do you also need, for Johnson versus Davis, do you also need to, let's say take for the sake of argument that that the problems themselves were drastically worse than any reasonable buyer would have been suspicious of by virtue of the report. Don't you need to have some evidence that the seller knew as well? I mean,
Absolutely.
this is a little different than painting over the mold.
Right.
Is Mr. Cassidy, is he an electrician by avocation or something? How do you know?
On the electrical issue, the defect that the Ewing sued for was that when they opened the walls, the wires looked like spaghetti. They were sliced with wire nuts and unprotected.
Yeah, how does the seller know that?
So when the Ewings did their diligence and were doing the repairs, they saw labels on the wiring that showed it was installed during the time when Mr. Cassidy owned the house. And there were no permits pulled. This was unpermitted electrical work. And therefore, there's at least a suggestion that Mr. Cassidy, Dr. Cassidy, knew about these issues, was on notice of these issues, and failed to disclose them. And under the circumstances, essentially what the appellees are arguing is that the court should apply a standard that because there's two issues that were identified, two minor issues, the Ewing should have upended the property, torn down every wall to inspect every electrical wire in the home because of those two minor issues. That's not the law. That's not what buyers are required to do. Buyers are certainly precluded from seeking recovery for any defects they were aware of or reasonably could have ascertained prior to closing.
But when a buyer is told, get a plumbing contractor, get an electrical contractor, get an engineering contractor, get somebody to check the foundation, and they don't do it, who's at fault for that?
It depends on who the trier of fact determines. I mean,
no, the facts are clear. Your client didn't do it.
Well, Your Honor, Judge Sleep.
Every report said, get somebody who knows how to do it. I'm just an inspector. I'm not an engineer. I'm not a plumber. I'm not an electrician.
But there were other issues that were clearly known by the seller, and they concealed and failed to disclose. So, for example, another claim involved flooding on the front property. In the seller's disclosure, Cassidy specifically represented that he wasn't aware of any flooding issues ever at the property. Now, after closing, there was a moderate rainstorm, and that resulted in standing water in the front yard and driveway of a depth between 2 and 3 feet that did not subside for several days. This was a significant issue. Once they learned about these flooding issues, the Ewings investigated and learned that Cassidy had in fact work performed in that area that involved installing a private drain that made the county storm drain inoperable, which was the cause of this flooding. And Cassidy says in his brief, the Ewing should have learned about this or potentially known about it because number one, the property is near sea level. And number two, there was some minor settlement of brick pavers in the driveway.
And also there was a sump pump, right?
But that's a different issue. That was inside the house. This is flooding in the front yard and driveway. There's a million.
Generally, I mean, so that's even lower than what would be in the house. So if there's a sump pump was higher, doesn't that tell you, okay, well, there could be the possibility. I mean, this is a coastal property, correct?
It is, but
so to assume that you're not ever going to have any flooding or water in your front yard, once again, is that not incumbent on the buyer to find out from whoever, the neighbors, whomever, and see, is there ever water in my driveway? Is there ever water I need to go through? Or to ask more questions of the seller?
So the buyer is certainly free to ask any questions, but Johnson versus Davis and its progeny says that the seller, if it has knowledge of issues, if it has knowledge of these defects, has a duty to disclose. And in a situation where the seller makes a misrepresentation, here, Mr. Cassidy, Dr. Cassidy made a representation that he wasn't aware of any flooding issues.
So let me ask, so that representation there, that's evidence in the summary judgment evidence. He said, I am not aware. So in other words, taken at face value, in my experience, it never flooded. So there's a couple, so we're here on summary judgment, issues of law, it's a de novo review. What inferences can be drawn either way? I am not aware, yet I have a sump pump in the mother-in-law suite, which, as Judge Startle mentioned, and we don't even have to take judicial notice that there are not many basements in Florida, probably not on an island, is above where the flooding was. So either under two scenarios, one, which is, Johnson, which is, hey, shouldn't you have known? But another one is again, going back to fraud, which is, did you justifiably rely on this seller saying, I don't remember ever flooding? And you're like, oh, well, there's a sump pump. Why would you have a sump pump then? I mean, under either standard, why should the plaintiff be able to recover here?
Before you answer, you're at 20, but we asked you a lot of questions. So I'll give you 2 additional minutes. Do you want them for rebuttal or you just want to use them now?
So, and I've gotten through about 2% of my argument, obviously, the court's questions.
Sorry.
That's, of course, I understand what the court is concerned about. And let me just go back to the 4th District Court of Appeal opinion in Lorber of last year. In that case, the 4th District Court of Appeal very clearly says a seller's false representation about a defect is sufficient to establish a fraud or misrepresentation claim, notwithstanding other facts suggesting that the defect was observable. What the Ewings could have observed, what they could have investigated and determined is irrelevant when there's fraud and misrepresentation. And ultimately, at best or at worst, it's a question of fact that cannot be resolved on summary judgment. All of these claims, when we're talking about the different cases that we've spoken about, Johnson versus Davis, that's a case that went to trial. The Pressman case that the appellees cite to went to trial. Nelson versus Wiggs went to trial. The Schottenstein Holmes case, the Florida Supreme Court said that should have gone to trial. There were numerous disputed issues. The trial court committed error because it resolved every single inference and every single disputed fact in favor of the appellees. Your Honors, I will reserve a remaining argument and refer back to obviously our briefs on the remaining issues that we didn't get to discuss.
All right. Thank you, sir. Good afternoon, counsel. I see 2 of you. Would you like to split your time?
Yes, Your Honor.
How would you like to do that?
Determined is that I'm going to take the first 15 minutes on behalf of Dr. Cassidy, and then Mr. Dudek is going to take the remaining 5 minutes on behalf of Michael Saunders and Company and the individual agent.
All right, sir. You may proceed, Mr. Waltz.
All right. Thank you, Your Honor. I want to pick up on just 2 concepts before I get into my argument. The other argument, 2 concepts that came up during counsel's prior argument just now. The first one from a question from Judge Atkinson. I think what we're going to see here, particularly from the inspection report, is that these buyers didn't have to be diligent. They were told of these defects in the inspection report. So that's one concept. They didn't have to be diligent or search for things. They were told of these defects. And the second concept that I think is important, particularly for the electrical as it came up, and I think it came up on another one as well, is that the standard for Johnson versus Davis is that the seller had to have actual knowledge of the defect. And I think as Your Honor was asking questions about the electrical, it became very clear that the what they had is at least a suggestion, only a suggestion, that the work was done while Dr. Cassidy owned the house. And the facts that are pretty clearly in the record is Dr. Cassidy didn't even live there for the bulk of the time. It was a rental property, and a suggestion that work was done while he owned the house falls extremely short, entirely short of the actual knowledge standard for Johnson versus Davis. So they just didn't establish actual knowledge on behalf of Dr. Cassidy with regard to the additional electrical problems that were inside the wall. I wanted to mention those two.
On that issue though, could you please apply it to the roof?
Yeah.
Was there not evidence that Mr. Cassidy was aware of something that was not ascertainable by the buyers?
Well, there might have been, but that's the roof is, I think, the clearest example. Actually, I think there were about 3 totally clear examples of what they were told in the inspection report gives them all the knowledge they need. The roof. Okay,
walk me through that. What is that?
Absolutely.
It's near the end of its use.
Well, they were told it was.
Does that say, well, when I move in, it's gonna just everything's gonna come down on my face?
Well, of course, no one knows what's going to happen with that, but I will address exactly what Your Honor asked, which is that the Maceo report, which is the inspection report for the Ewings, in the context of the contract, that they had an inspection clause in the contract that allowed them to get out of the contract if they did an inspection and found in their sole discretion any problem that caused them concern. So the Ewings could get out of the contract upon finding any problems. The Maceo inspection report has a kind of a code denoting some things as defective, some things as marginal, and some as lesser. I'm obviously going to be talking about defective and marginal here. Defective is defined as needs immediate repair or replacement. Needs immediate repair or replacement. Second phrase, it is unable to perform its intended function. And the roof is defined in the Maceo report as being defective. On top of that, that's just the report itself. On top of that, we talked a little bit about the agency issue. We absolutely contend that the Ewings have imputed knowledge through their agent Williams. Williams knew that they needed a new roof. There was open knowledge between the agents. It was discussed. It was absolutely clear that they needed a new roof. If the roof is defective and it needs immediate repair or replacement, they've been told that they've got a defective roof.
Okay, so needing a new roof, but what can mean many things. It could mean the shingles. And is it perceivable that there is a fact issue as to of exactly what that put the buyer on notice when there was potential for something much more than a new roof? I mean, does a new roof usually include all the support structure for the roof, or just the shingles?
Well, I contend that a new roof is everything that goes into a roof. Shingles
based on what?
Well, for one thing, the inspection.
So you contend, but what does the summary judgment evidence indicate that being on notice that you need a new roof means?
The summary judgment evidence was that their agent knew that they needed a new roof, that the inspection report told them they needed that their roof is defective, and at the end of its useful life and does not perform its intended function. So what I take that to mean is that anything that's wrong with the roof, they need to fix it. They need to fix it, and it actually says immediate repair or replacement in the inspection report. The To my
So
recollection, the summary judgment evidence did not parse between shingles versus other. They made that argument, but the summary judgment evidence did not parse between the two. Clearly, when they arrived on the property the very first day, the shingles were surrounded around them on the ground, and that remained that way. It was perceived as being literally too dangerous for someone else to get on top of the roof. But they were told it was a defective roof that needed immediate repair or replacement. And I think that's where the judge landed, is that if you know you have a defect, they claim they had their allegation is they had a defective roof, and the inspection report told them they had a defective roof. And that's the same thing with the plumbing. The plumbing report, there were two inspection reports that bore on the plumbing. I'll start with the Maceo report. The Maceo report told them they had.
Before you go to that, I have a question on the roof, but just to finish up Judge Atkinson's question. So sure, you've got shingles or clay tiles or whatever you end up having on a roof structure, and then there's the underlayment, and then under that you're going to have some sort of a foundation. There was something in one of these that said it was difficult, I guess, to get up into certain areas of it. But they were on notice that, I guess your position, they're on notice that they need to get into the attic, they need to get up and observe whatever it is to see the extent of the roof damage.
Our position certainly is that they're on, just using the words of the inspection report, on notice that they have to immediately repair or replace their roof.
So whether that involves more than what's there, or just the shingles, whatever it is, wherever the water damage has gone down to, that's their responsibility because they're aware that there's a roof problem.
Absolutely, and putting it in context of the contract, and it's paragraph 12 of the contract, once they're aware from that inspection report that they have a defective roof that needs immediate repair or replacement, they have a choice. And actually there are probably three choices they might have. They can get out of the contract immediately. They can go to the seller and say, hey, I've just been told I have a defective roof, you fix it and then I'll buy your house. Or they can close under this as-is contract, knowing that they have a defective roof.
I'll add a fourth. They could renegotiate the price.
Exactly. Well, I was kind of rolling that into that first option I gave, where they can go to the seller and say, you pay for it. But yes, they can renegotiate the price. But they elected the option of knowing they have a defective roof that needs immediate repair or replacement. They chose, let's go forward and close on this as-is contract. And they made that same choice on all of these other defects. The plumbing, parts of the plumbing were defective. The vent pipes, the water lines were marginal. The drain pipes were defective. There were active leaks in the vent pipes. There's an active leak up in the attic from the vent pipe. There's an active drain pipe leak down into the non-conforming mother-in-law suite. With those defects, they likewise chose, with knowledge of those defects, to go forward and close. And then the pool deck is another egregious example. The pool deck, they even had an escrow agreement because the buyers knew they were going to go work on the pool deck. The escrow agreement focused on the permitting, maybe back permitting costs for the work they're going to do. But the inspection report on the pool deck said it's not safe. Don't go on there without an inspection from an engineer. And it specifically said that is not properly supported. And as I read their allegations now, what they're saying is, oh, you didn't tell us it wasn't properly supported. Well, the inspection report told you that. You knew it was not properly supported, and then you made that choice that I talked about. You made that choice to close on the deal, knowing that you have a defective pool deck, defective plumbing, defective roof, leaks in the area of the master bedroom, both in the closet and in the attic above the master bedroom. You knew about those. And on that one, there was a testimony from Mr. Ewing's deposition that maybe he should have done something about that. Maybe he should have asked about that leak. He didn't. Instead, he closed, knowing he has a leak, and then complains about the consequences of the leak he knew about. So I heard Mr. Kalaya talk about concealment, but all of these issues that they've alleged with concealment, we talked briefly about electrical. It was in the walls, and there's no proof of actual knowledge on the part of Dr. Cassidy. The plumbing, the roof, the concealment doesn't work because they were told and have actual knowledge. The Bassett case that I think that they referred to, you can rely on a truth of a representation unless you know the representation to be false or it is obvious. And if they were told, hey, you have no problem whatsoever with the roof, and then you get your inspection report that says you have a defective roof that's at the end of its useful life, no longer serves its intended purpose, you know it to be false and it's obvious.
Real quick, that what I'm describing perhaps improperly as an exception to, the right to rely. Is that applicable outside of commercial real estate?
Outside of commercial?
Yeah, the Bassett case that was.
My understanding. My understanding is that as I was approaching it, that theory applied that yes, you have a right to rely unless it's known to be false. That's what I understood the law to be. But our point is that on these particular defects that they are complaining of, they knew them to be false. I mean, for example,
you're talking about that a recipient may rely on the truth of representation even though its falsity could have been ascertained had he made an investigation. And I was perhaps focusing on that. You're focusing on unless he knows the representation to be false or its falsity is obvious. All right.
And that's the one-eyed horse.
Right. Okay. So if it's not a one-eyed horse, but maybe the horse has macular degeneration, then the other clause might be operative, which is even though its falsity could have been ascertained had he made an investigation, that I invite anybody to correct me if I'm wrong because I might be. It doesn't apply outside the commercial setting, I don't think. In other words, if there's, I don't know if it's a fulcrum point or it's a gray area or a slack tide or whatever between if the horse has, one eye or the horse, has myopia, then if it's just, hey, well, you could have ascertained the falsity based on some diligent investigation. I'm not sure that applies outside a commercial real estate transaction. Whereas you're saying, well, even if it's residential, if you know it's false, you can't rely on it. That just sounds like fraud. I mean, that means that's just no reliance. It's not even something you need.
Well, it's not justifiable. It falls in the same.
It's not justifiable reliance. It's not even saying anything unique. Hey, well, obviously you have to justifiably rely on it. So, but isn't the operative phrase in Bassett, even though its falsity could have been ascertained had he made an investigation? Unless, of course, you're correct, which is that, it was obvious that Mr. Cassidy was lying, but where is that obviousness in the record?
Well, the obviousness starting point is in the Maceo inspection report. I mean, first of all, I don't concede that Dr. Cassidy was lying.
I didn't think you would.
but in the context of all of these defects, we've talked about the roof, we've talked about the plumbing, we've talked about the pool deck. The defects they're complaining about are in the inspection report as defects, as these items are defective and they need immediate repair or replacement. And for example, on the plumbing, what they complained about as a defect in their complaint is that the plumbing was unpermitted. Well, the inspection report tells them that the plumbing was unpermitted. So they knew it prior to closing.
You're at 15 minutes, but I'll let you finish answering the question.
Okay, so the point is that they knew what they needed to know affirmatively from the inspection report and from Williams, imputed knowledge through Williams, had affirmative knowledge of these things. that even if there's some allegation that they were misled in some way by Dr. Cassidy, they had affirmative knowledge that these things were defective before they closed at a time where they had an option under paragraph 12 of the contract to simply walk away. And they chose instead, with that knowledge, to close. So in closing myself, Your Honors, we're asking that you affirm the final judgment as it relates to Dr. Cassidy. Thank you.
Thank you. Mr. Dudick.
Good afternoon. As Mr. Wallace mentioned, my name is Kyle Dudek. I represent two of the appellees in this case, Ryan Skarpowski and Michael Saunders and Company, and they were the real estate agent and broker for Dr. Cassidy. Before jumping in, I want to take a second to reorient things. I know we've been discussing a lot of defects in the roofing, in the pipe, in the pool deck, but the claims against my clients are limited. The only alleged misrepresentations in the complaint as to the broker defendants, who I'll refer to my clients as, were two. And first is that the property contained 300 feet or less of water frontage. And second was the ground floor of the house could not be used as a living space. Those were the only two misrepresentations that were made to allegedly made by my clients. Now, the issue about the lower floor being livable space, that's been abandoned, that hasn't been brought up. The only issue that was presented to the trial court for summary judgment and is here today is about the water frontage. And right at the outset, as opposing counsel noted, there was a misrepresentation. The MLS listing from my clients said that the property had 300 foot of water frontage, and that was incorrect. The actual water footage is closer to 100 feet. I believe it's 110 or 104. But the problem with the plaintiff's claim about that misrepresentation is the reliance element, which Judge Atkinson, you talked about, is that even if you have a misrepresentation, you still have to prove that you reasonably relied on that misrepresentation in entering the contract. The problem the plaintiffs have in this case are the facts are undisputed that the day after the Ewings went out to the property, there was a call between my clients and their real estate agent, Ray Williams. And during that call, it was told to Mr. Williams, there is not 300 feet there. There is less. It's closer to 100. And you can see in the testimony of Ray Williams, he says that they had that call. He says that he was told that it was less than 300 feet. He also says that on the date that they inspected it, he paced it out and said it was less than 300 feet in front of the Ewings. And there's an email correspondence from Mr. Williams to my clients saying, we have concerns about the water frontage. So this is not a case where there was a misrepresentation about the MLS listing that carried all the way forward to closing, and they relied on it believing they had 300 feet. It was told by my clients to Mr. Williams that it had less than 300. So they cannot, under the facts, say that they relied on that initial MLS listing any longer. Now, there's been some discussion in the reply brief that the knowledge to Mr. Williams shouldn't be transferred to the Ewings because he was acting in his own self-interest. And in those circumstances, the knowledge isn't transferable. Well, the problem with that argument is it was never raised in opposition to summary judgment. It was never raised on the motion for reconsideration, and it was never raised in their initial brief. What they've done is they've just taken that issue, raised it for the first time in the reply brief, so I would say it's waived. But the second part, the case they rely upon for that statement is not a Johnson v. Davis case. It's in the context of a different transaction. And in a Johnson v. Davis case, you're dealing with a very specific relationship, and that's between four parties. You have a buyer, seller, and then the real estate agents for each. And the obligations, as I'm sure all the panel knows from having probably bought a house in their own history, is that the communications are usually between the agents. The seller talks to their agent and the buyer talks to their agent, and that's how things are disclosed. And then the agents talk to each other. There's no direct conversations between each agent and the other side. And so by disclosing it to Mr. Williams, they did what they needed to do to correct that misstatement in the MLS listing. There was nothing more that they could have done. Now, even setting aside the issue of what Mr. Williams knew and whether it can be transferable, you fast forward to the day of closing. And the day of closing, they receive a document, the survey. And the survey lists the water frontage at less than 300 feet. So even if you can say that Mr. Williams's knowledge can't be imputed, they had, prior to closing, in their hands a document that said it's less than 300 feet. Now, they've said that the survey was a forgery, that there's an issue with it. That's all fine, because the problem is that it put them on notice at that point that there was an issue with the water frontage. And so they shouldn't, having that survey in their hand that shows something different than the MLS listing means they can't rely on that statement of the 300 feet before. And setting all that aside, the only thing that they've shown about the survey that was inaccurate was some date that apparently exists on there. So, and the end of the day,
I have a question for you just in general, because I know your time's, and both of you can answer this. From the standpoint of the contract itself, you're talking about at the end of it, but at the very beginning, it's an as-is contract as opposed to the standard contract. What difference, if any, do you say that makes in this transaction?
Well, for my clients, I don't believe it makes much, if any, in the sense of we've got Johnson v. Davis claims on my end that deal with an affirmative misrepresentation made. It's not a failure to inspect on their end. So I believe that might apply more to Mr. Wallace's.
Right, I agree. I wanted to see and give you both a chance to answer that.
Sure, and I'll certainly leave a little bit of time at the end for Mr. Wallace to chime in there. So
Mr. Wallace has used his time. You've got 30 seconds.
Okay, so at the end of the day, the court was faced with those facts, that it was disclosed to Mr. Williams and that they had a survey showing that it wasn't 300 feet. And the court made the decision that the only decision that can be made from the record is that there could be no justifiable reliance on those facts. And so with that being said, I believe I'm out of time. And unless the panel has any additional questions.
I don't think so. Thank you, sir. Mr. Kalai, I'll give you a minute and a half.
Thank you, Judge Sleet. So, Judge Stargell, almost every contract in Florida for residential sales is an as-is contract. That's a standard contract that's used throughout the state, and it doesn't displace Johnson versus Davis. I want to note briefly that the parties are almost talking past each other. The appellees are saying that the buyers knew about certain defects, so therefore, according to the appellees, the buyers can't recover for any defects, no matter whether the appellees knew about and actually conceal these facts from the Ewings. That is not the law. That's not permitted under the standard. So, for example, on the roofing, and Judge Atkinson was asking about this. In the seller's disclosure, Cassidy made the following statement: "Has the roof ever leaked since you own the property?" He answered no. And beyond that, he went forward and wrote in his own handwriting, "I bought the house 9 to 10 years ago and no roof problems." That's what he said. But during discovery, the Ewings obtained emails, and this has been submitted on the record, that Cassidy was told about additional necessary repairs, and that if this work wasn't performed, quote, "the roof is just going to leak somewhere else." Cassidy responded to that email and said there was, quote, "no need to get estimates on the roof, as I won't be doing major work on it." So that the evidence is clear in this case, or the record is clear, that there's facts establishing that Cassidy knew about these defects, made specific misrepresentations, and at a minimum, there's a disputed issue of fact for trial about to what extent the Ewings are able to pursue these claims. I want to talk very briefly about the broker and agent. They say that there's two issues.
Very briefly.
They mentioned that there's two
10
issues.
seconds.
Well, Your Honor, with 10 seconds, I will ask the court to please reverse the order on the trial court. The amendment was denied improperly. The summary judgment should have gone to a jury, and the court improperly refused to allow rehearing or reconsideration. On those bases, we would ask that you reverse.
Thank you very much. Well argued. All of you have a nice day. Good to see you. We're adjourned.